May I, Your Lordship? Your Lordship, I beg to mention item number 25, Your Lordship. This matter may be listed after 3 weeks.
Twenty-five. 25.
Yes, Your Lordship.
What is the matter about?
This one, retrospective promotion from inspector to DSP.
From inspector to DSP.
Yes, Your Lordship.
APC is convened vendor.
Huh?
APC is convened vendor for the post promotional social DSP member. Then we are seeking matter, this matter from the actual date of vacancy matter, the promotion has. to be-
Okay. After 3 weeks,
Yes, Your Lordship.
on the prayer of this. People on the government advocate, listed after 3 weeks.
Otherwise, Your Lordship.
Lordship,
Item number 12, 13 and 14, Your Lordship.
Hmm.
This matter may be listed after 6 weeks.
12, 13. After,
6 weeks, Your Lordship.
what is the matter about?
This one is land compensation matter, Your Lordship.
Why after 6 weeks?
As instructed by this one, Your Lordship. Council of the petitioner, Your Lordship.
As instructed.
No,
by the coun-
no, AAG, Your Lordship.
Who?
AAG, Arish Nabam, Your Lordship.
Hmm. There is a interim order operating against the government. Since 2019. If you concede, you concede. If the government don't want to fight back the case. What is the rationale for seeking adjournment for 6 weeks in a matter which is pending since 2019, where an interim order is operating against the government? Yes. Who will see what is to be done?
Okay.
Ma'am, Lordship, for, I'm mentioning for listing of the matter, WPC 192 of 2023. Tender, it's a tender matter. For tomorrow,
Pending case.
yes, ma'am.
Why tomorrow?
There's an interim
Uh,
for admission,
have you filed affidavit?
yes, ma'am.
Okay, all right.
Lordship, I beg to mention item number 4 on behalf of N. Tajed for adjourn today.
Yes. What is the matter about?
My lord, matter is non-releasing of monthly salary by DMO Lower Subansiri District. Non-releasing of monthly salary.
Non-monthly salary.
Yes, yeah. So leading counsel is out of station, therefore the matter may be just after 3
Affidavit has
weeks.
been filed. Counter affidavit by the state has been filed.
Yes, Lord.
When do you want?
We have filed matter.
No.
They should have informed me. That's
Why are you denying petitioners their salary?
this is the petitioner was one time in 2007 or 6 months. He was appointed on ad hoc basis, and later on the appointment was withdrawn. As appointment was made against a non-sanctioned post. There was no sanctioned post.
Oh.
So thereafter, he has never worked, man,
Oh.
for last 14 years. And now all of a sudden he come with this writ petition, claim for salary, which he had never worked for last 14 years. We have filed the affidavit.
On the prayer of Mr. Your good name?
El Takam,
El Tatam.
yes.
Shall we counsel for the petitioner? So then we can dismiss your case. He is saying that you are asking for a salary for the period for which you did not work. And there was no any valid appointment order also, no post also.
My lordship, let my senior may come
All right, we'll
All right.
dismiss after 4 weeks.
Yes.
4 weeks, after 4 weeks.
after 4 weeks. Okay, oblige.
Ma'am, Lordship, I beg to mention item number 11, ma'am.
7,
11,
11.
this matter will be listed next week, ma'am.
Why?
Compensation matter.
Which compensation? Land compensation.
Yes, my lord.
Have you filed affidavit?
Yes, my lord.
What kind of a land compensation?
They're challenging that they are paid less, my lord.
Solation, they're asking for solation.
My lord, including solution,
Land has already been acquired.
already accurate.
Acquired
There is
under Zoom land.
Yes, madam.
You say that you should be paid compensation in terms of 2013 Act.
Yes, my lord.
You are relying on Milani's case.
No, no, my lord. This is something different. There is an anomaly in the calculation of compensation. Wrongly, they have calculated the numbers.
Okay.
So they have also admitted certain facts that they are ready to pay 17 lakhs to me. I am refusing that
So up to 2 weeks.
after 2 weeks, ma'am.
Okay. On the prayer on the council parties listed after 2 weeks.
Your lordship, I beg to mention item number 23. Matter may be listed after 4 weeks. I have taken concern from the other parties also.
23.
Yes, your lordship.
What is the matter about?
This is the challenge, the order of DC owner regarding LPC.
LPC.
For the respondent, as I have to file the affidavit in opposition, so I need some more time.
Okay. They respondents have filed affidavit.
No, I'm for the respondent, so I need some more time to file the affidavit in opposition.
You are for which respondent?
3 and 4.
3 and 4. Have you informed Lani council for the other side?
Yes, yes.
Yes, I for the petitioner also.
Okay. Will grant him time to file?
Yes, also. Since they have been seeking adjournment for last 3 occasions also.
No, not 3 occasions.
Maybe given the last chance.
Government has filed affidavit.
Yes, your lordship.
Yes, they.
How much time? 3 weeks.
4 weeks.
Okay. On the prayer of Mr.
L. Naran.
L. Nara. Learned council for the respondent number
3 and 4.
2 and 4.
3 and 4.
3 and 4. 4 weeks further time is granted for filing of the counter affidavit. Listed after 4 weeks.
Obliged.
My lord, I beg to mention item number 15.
Yes. Yes,
Leading counsel is after discussion and
you are
moreover,
for whom?
petitioner. I'm for petitioner.
Petitioner.
Yes.
Who is the leading counsel?
T. Torum.
Huh?
T. Torum.
T. Tava.
Torum.
T. Toro. Where is he?
He is out of the station.
No. You wait, let us. You wait. When do you want the matter to be listed?
After 2 weeks,
After 2 weeks. Okay, on the prayer of Mr.
T. Taze.
T. Taze. T. Taze, learned counsel for the petitioner, listed after 2 weeks.
Obliged.
Your lordship, I beg to mention item number 18.
Item number?
18, your lordship.
18.
Lassi conjugate, your lordship.
Yes.
Leading counsel is out of station, kindly matter to be released after 2 weeks, your lordship.
Okay, on the prayer of Miss
C. Ronnie,
C.
RONI.
You are for the petitioner.
Yes, lordship.
Counsel listed after 3 weeks.
2 weeks, your lordship.
Okay, 2 weeks.
Obliged, your lordship.
Instruction, madam.
Residential school coordinator.
For the appointment of coordinators. Instruction it was sought.
Just a moment. You are challenging? You are challenging which order?
Page 51, my lord. By which order, my lord, I have been transferred to
You are a JT.
I am a JT, my lord. An immediate previous page, my lord, kindly be seen. That is the appointment order dated 17 October 2022.
Your appointment order.
My appointment order as coordinator, residential school. And page 51 is the order dated 4th July 2023. By which order I have been transferred to academic health hygiene, that is also equivalent to post of coordinator, from the post of residential school coordinator. So here in this case, my lord, my case is that the private respondent number 4, that appears at serial number 2, does not have the requisite qualification for the post of coordinator, and he cannot be replaced me.
You have now been transferred as academic health hygiene.
My lord,
Academic health hygiene.
my lord,
Which school?
that is under the DDSC office.
Oh, judicial.
Ah.
And you are
And-
working as
Uh,
JT.
JT,
Where?
middle school Daporijo, police colony.
Ah. And where is that? Where is that? Middle school.
Daporijo.
Hmm. He is really. You want to be a Daporism? You
No,
want to be a Daporism?
No, my lord, actually, I am still in Daporijo.
Ah.
But then this junior teacher, my lord,
Ah.
those who have the B.Ed qualification, they are eligible to hold the post of coordinators
Hmm.
as per the 9th executive meeting.
Hmm.
And accordingly, having that requisite qualification, I was appointed as the coordinator for residential school by order dated 17 October 2022.
Previous page.
Previous page.
Okay. Look after the intervention of residential school under Samagara section.
Now, only issue, my lord, in this case,
PRT is what? JT,
primary teacher.
primary teacher. You are
I am
JT.
junior teacher,
higher.
or in other
T-
word, TGT, trained graduate teacher.
TGT.
My lord.
Okay, it was in that context, this instruction was sought for.
Sought for,
That who,
only to ascertain.
who can be appointed as
Yes,
residential school. Yes, Mr. Jama.
My lord, very sorry, my lord. We sought time for this placing our instruction, but due to my ill health, I could not place it. Your lordship, it is with us now. The instruction is with us.
Who can be appointed?
Appointed means any teacher, my lord, any teacher with having who is having sound academic background with B.Ed, my lord. It is there, my lord.
Just a moment. Huh? The writ petitioner had relied on some notification.
My lord, that we also have agreed. I have seen that, my lord.
He has agreed to that, my lord.
My lord,
We both are agreeing
my
that.
lord. It is,
What is this instruction?
instruction says, my lord, my lord, instruction one, my lord. May I read, my lord? Instruction one. At the outset, it is made clear that coordinators are not substantive posts, but temporary intervention to be looked after for implementation of various components under the ISSE, in which regular teachers are entrusted, engaged in as coordinator. There is no such guideline for appointment of program coordinator in district and level. However, framework was drawn in minute of the 9th executive meeting of SSA Raja Mission Society, Arunachal Pradesh, on dated 22 November 2011 at Itanagar, The framework drawn in the decision of the 9 executive meeting is still followed for appointment of the program coordinator in the district. However, it may be noted that the said minute also does not confer any legal enforceable right to any incumbent. They are not statutory rules nor act. The petitioner has annexed the minute of the meeting dated 22 November 2011 in read petition, page 22, my lord. The paragraph number 11, it is observed clearly provided that the executive committee has approved for appointment of BRC, CRC district coordinator for different intervention for the teacher with sound academic background, only 10 years teaching experience with B.Ed, DL, my lord, diploma in elementary education, my lord. The DPDs, DPOs shall be the appointing authorities in the district level. DPD means, my lord, district project director, and DPOs means district project officer, my lord. Hence, any teacher under the department, PRT, TGT, PGT, may be appointed as coordinator in different interventions, provided the incumbent has 10 years of teaching experience, sound academic background, and having educational qualification of B.Ed, DLED. Sri Taporgaram, PRT, was regularized in the cadre of PRT in the year 2008, and he is possessing MA B.Ed. Taken from the year 2008, his teaching experience is more than 10 years, hence appointing him as coordinator residential school ISS is not wrong, Your Lordship. And we sought another instruction, number 2, my lord. Our query was, what is the status and position of the coordinator of the residential school ISSE? Is that a substantive post? Coordinator of any intervention under ISSE is not a substantive post. They are assigned the duty of coordinator temporarily at their own scale of pay they are entitled to from their substantive post of TGT, PRT, and attached under the establishment of the DDSE. They have no legal right to be permanently function as coordinator. The main duty of the teacher is classroom teaching. However, under administrative exigencies, some PRTs, TGTs are temporarily engaged and attached as coordinator, like a dealing assistant of the particular intervention under ISSC. They function like dealing assistant, my lord, for keeping records and all, my lord. Status and position of the coordinator of the residential school ISSC. ISSE program is implemented through the DPC, DC, and DPO, DDSE in the district. DPD is an ex officio functionary under the program. Practical execution is actually done through the DPO, DDSE in the district. One district project coordinator is appointed from the ISSE headquarters, Itanagar, for monitoring all the components of the ISSE. There are numerous components under the ISSE like pedagogy, academic, uniform, gender equity, health and hygiene, residential school, inclusive education, vocational education, sport and physical education, infrastructure development, and retention, etc. All these components are monitored by the district project coordinator appointed from Itanagar head office. But for proper record keeping and official dealing, coordinators of the different interventions are engaged, appointed in the district level. They are in fact temporary dealing assistant for the intervention, coordination, residential school ISE means he is simply a temporary dealing assistant, clerk of the temporary intervention of the residential school who maintains the record of the residential school of the district under the establishment of the DDSE DFO.
Just a
DP.
moment. The petitioner had relied on which one? Clause 12.
My lord, my
12,
my lord,
12, my lord.
Clause 12.
my lord.
What does it say?
Your lordship,
It says, from teachers with sound academic background, not necessarily TGT.
my lord, not necessarily.
There is a wit.
Huh?
From teachers with sound academic background, only 10 years teaching experience with B.Ed or diploma in elementary education. That is in under bracket, 10 years teaching experience with B.Ed.
My lord.
You,
It is
the respondent does not have this.
B.Ed.
Be it.
neither diploma in elementary education.
My lord.
To
record
that
is here.
effect, my lord,
Record is here.
we have
But he is MID, I think.
MA, my lord. and
MA,
MA and
MA, be it.
he has his,
B.Ed, he doesn't post.
no, my lord, he has, as per record, he has. It is the record.
Kindly,
Be it or the.
my lord, on that day, my learned friend has told me that he had on the first day. I don't
Yes,
know from
yes.
where he gathered the information. So accordingly, we have filed the RTI application. And this RTI application speaks, my lord, that this person do not have B.Ed. And this RTI application,
Have you annexed this document in the writ petition?
not yet,
My lord.
Why not?
The
but then
instruction-
I have specifically stated in my pleading paragraph 2 that this person do not have B.Ed.
Okay.
My lord, in the record submitted, supplied to us, my lord.
Just.
I don't know from where they have collected, but the in the office, B.Ed certificate is not available.
What is your name? You are not Tapi Kamra,
No. This is respondent number 4, madam.
respondent number 4.
Ah.
Who is respondent number 4?
He is, my lord, I am Tapen Kunyaman. Respondent number 4 is Tapor Garam. It's showroom. ma'am.
And who is this Tapi Kamra?
Tapi,
Kamra to whom this RTI information has been furnished?
or that is my relatives,
Your relative.
my relative.
Okay.
This is very surprising. my lord.
Then let us see your record.
My lord.
Yes.
I have been informed, my lord, in the degree of B.Ed has been submitted in the Director of Elementary Education, and it has been accordingly updated, my lord, here, but that has not been updated in the DDSE Daporizo, my lord. So this man undoubtedly possessed this, and even in his seniority list reflected in our web portal, my lord, in his position, web portal, my lord, we have shown him having MA B.Ed, my lord. That his list is in 580, my lord. 580.
His submission may be taken note of, my lord.
My lord, that can be, because one seniority list is there, my lord.
Seniority list.
My lord, it is very voluminous, my lord. And
Yes.
there,
See, when you receive a voluminous instruction,
my lord,
you should paginate it.
my lord, very sorry, my lord. I will take care of that from today, my lord. Your lordship,
Yes.
I have this mark it out, my lord.
No, I'm now I've got
Yes,
it.
yes, my lord. My lord, 580, my lord. This has assumed finality, my lord. It was finally the provisional, but it has assumed finality because there was no objection, my lord. Notice for objection was given, my lord.
No, this provisional seniority is dated.
Your lordship, preceding page, my lord. May I read, my lord? Preceding page. It is for general information to all the regular primary teachers working under the Director of Elementary Education, Government of Arunachal Pradesh, Itanagar, that updated provisional seniority list of regular primary teachers, PRT, has been uploaded in the department website, http://education.arunachal.gov.in. For claims and objection in seniority list, teachers may contact to the office within a authenticate document on or before 15 August 2022. Late submission shall not be entertained at any cost, my lord. So this provisional seniority list expired on 15 October 2022, my lord. My lord, it is very much in web portal, my lord. That I will ascertain right away, my lord.
Then you file affidavit within a week.
My lord, we
Bring the record also.
my lord. My lord, it is a matter of the Daporizia, my lord.
If you say that, then we'll pass order.
2 weeks, my lord.
If you can file affidavit within a week,
2 weeks, my lord.
make the records available,
My lord.
we will dispose of after a week.
Oh.
If longer time, then we'll pass order, we issue notice.
Okay, notice may be issued, my lord.
Okay.
Notice may be-
There will be stay also.
My lord, staying would be, my lord, he has already joined, my lord.
See, there are two disputed questions of facts have come up.
My lord,
His evidence is equally believable.
my lord,
And we have also no reasons to doubt your evidence.
my lord.
So under the circumstances, we issue notice and stay that, then find out what is what.
My lord, give me 2 weeks then, my lord, at least. 2
No.
weeks.
This repetition, see, this repetition was filed when?
11 July.
11th of July. It was taken up first on 12 July. And then on another date also today. too. The choice is yours.
Okay, we'll try, my lord. 1 week, my lord.
Which date? Which date? Are you appearing for a private respondent? Okay.
I'm a caveat also.
Oh, there is a caveat also. Yes, what is your qualification?
Lordship, I have, position, I did my MA and after that I did my BEd also. Lordship.
B.Ed also.
B.Ed.
When did you do it?
It was like. In the year 2017.
17.
Lordship, so far, before going into the merit of the case, Lordship,
Ah.
to my humble understanding, Lordship, since this is the matter wherein the post which has been assigned before this honorable court by passing an order by the mediation, Lordship, that cannot be challenged before this honorable court, because on the ground of that, Lordship, I'm raising a questioning of maintainability also, Lordship. Substantive post is TGT, Lordship, no doubt, like, I'm working as a PRT, Lordship, primary teacher, Lordship.
Your substantive post is also PRT.
PRT,
His
Lordship.
substantive post is
Lordship.
also TGT.
Lordship, so far as the minutes of meeting, Lordship, dated 2011, Lordship, close 12, Lordship, it's clearly stated that having a background, sound background of 10 years, neither it has been prescribed the PRT, nor TGT, Lordship. Since the annexes which has been annexed in the petition, Lordship, in the 2008, I have been appointed as AT, Lordship. And after from the 2000 onwards, if we counted that more than 10 years has been passed in this.
Whose, yours?
Right.
Ah.
And now the lordship, the post which has been assigned before this honorable court is only the assigning duty lordship. It's not a substantive post lordship. And before the lordship, since to my humble understanding lordship, promotion is not a matter of right also lordship.
This
And
is not a promotion.
This is not a promotion.
This is an
Just-
assigning of an additional duty.
Exactly lordship. I'm just thinking.
So
I'm just thinking.
they have prepared one memorandum in the meeting or something like that,
Lordship,
that any teacher
lordship,
with 10 years experience having B.Ed degree,
lordship,
his contention is that you don't have the B.Ed degree.
lordship, I have
Mm.
B.Ed degree lordship.
That's what Jamo is also arguing. So you'll have to file those evidence on record.
Exactly lordship. Lordship,
So file within a week.
we'll try that lordship. But so far as the interim is concerned lordship,
Ah.
the court has to satisfy that whether there was any illegality has been committed by the respondent authority or not.
Oh, no, you see, if you are willing to file within a week, we will not pass interim order. We'll fix it there just after a week. All right. Jamo has agreed to that.
Because lordship, to my limited understanding lordship, so far as the law is concerned lordship, but the person who approached the report lordship, he must establish the right lordship, and the same right has been illegally invented or treated by the respondent authority.
Hmm.
Now this is only the assigning authority, assigning lordship. He has not been transferred from the Daporis to anything.
Hmm. No, his allegation, his limited contention is that you are not qualified.
Lordship,
And you said that you are qualified.
lordship,
That has to be ascertained after the evidence is brought on record.
lordship.
Will you-
Lordship, I'm just having, I'm just giving a small proposal to the lordship. Our submission will be recorded and we'll try to file the affidavit within a week, lordship. And lordship, and if lordship, and so far as my understanding is concerned, lordship. Stating before the lordship is that since I'm having a PhD degree lordship, with MA lordship. And if that is found to be false lordship, then I will be prosecuted under the criminal law lordship. That is 193 of the IPC lordship.
Hmm.
The question of forgery does not arise, lordship.
Hmm. So we'll examine this after a week.
Lordship,
You file it on record.
lordship will try to do that, lordship.
Which date, Mr. Jamo?
My lord, 4th, my lord. August 4th, 4th August.
Fourth is okay.
Pardon, Lord.
4th of August is okay. Today is
Today is 36 lordship.
26. Yes. 3rd of August.
3rd of August.
3rd of August.
My lord.
Thursday.
Endeavor shall be made to dispose of the matter on that day.
You may also file this.
Ah,
Not Mr. K. Tamalan, counsel for the petitioner. Mr. P. Jamal, learned standing counsel for the education department. Representing respondent number 1, 2, and 3, and Mr. P. Gara, learned counsel, who has entered appearance on behalf of respondent number 4 by filing a caveat, being caveat number 70 AP of 2023. Why have you made this Procter party?
DDSC,
All right. You should notice.
because Malafide I have alleged.
You should notice. Returnable on 3rd of August. Just a moment. Before that, now the council for the respondents 1 to 4 have agreed to file the counter affidavits on or before 3rd of August. And let be of the matter, let notice be issued returnable on 3rd of August. First of, since respondent 1 to 4 are represented by their respective council, no formal notice. So no formal notice need be issued. Post extra copy of the writ petition, sir. Post of. This test for service of notice upon respondent of 5
By Dusty maybe allowed us.
be. Okay, Dusty. Okay. Be taken by. Okay, not, step for service notice of respondent of 5 be taken by registered post with AD. Within 2 days. Dusty in addition is also permitted. Listed on 3rd.
Endeavor cell.
Now we'll do that.
Highly always.
On the next date fixed, London Standing Council for the Education Department shall also produce the relevant record. Okay.
Record in original, my lord. We have, otherwise we have already produced record, my lord.
Record has to be produced.
Record
How
we have
that was
already-
initiated.
In original.
Original,
original.
in original, okay, okay.
Highly obliged.
Obliged, my lord.
You take this back. All, no?
Oh, okay.
Give it dishes.
OSIPA, I was directed to produce the original records.
Does it contain the number?
Lossi.
Does it contain the number?
Yes, I think regulation is there. Yes. With I produced the WhatsApp with the photocopy. So this honor court actually is willingness to produce the original one. Thus I have played the relevant document. The plague, the pink plague note. Pink plague. That is the bid submitted by the petitioner. Petitioner's bid document lawsuit. Pink plague is the lawsuit affidavit filed by the petitioner along with the bid documents. And lawsuit will find that the numbers is not their lawsuit. And other 2 documents, one is the bid of the private respondent, 6, and another one is of 7 lawsuit. There also I have played with pink color. Lordship will find on the top lordship, the same number is here lordship. And this registration number lordship is a very pertinent lordship because this is the entity of the very document lordship that it has been educated before the concerned magistrate. And in the documents of the petitioner lordship, some other affidavit also is there lordship. Lordship will find even the dates are not given there lordship.
What is the affidavit of Continental Traders?
One is of Continental, the other one is for Continental Traders lordship. They are also the same pink color lordship like.
Yes. Tatak,
Lordship.
there is a number there. You want to have a look at?
Lordship will solve it.
What was the, okay, what was the reason for rejection of your bid?
Lordship.
Where is that?
Rejection, grounds for rejection is at page 125, Lordship.
125.
May I read, Lordship?
Just a minute. Yes,
With reference to your letter number so and so regarding disqualification of technical bid against the work so and so by the bid evaluation committee. This office has gone through your complaint for disqualification in technical bid thoroughly and found that your documents have not fulfilled the technical compliance at serial number 20 and no affidavit number in all stamp paper submitted by the firm.
okay.
Lordship, admittedly, that no number has been given as per the inquiry before the competent authority. However, Lordship, Lordship is aware that as far the this particular registration of the affidavit or giving number to that particular affidavit, since this is a self-declaration affidavit. Self-declaration affidavit as per Registration Act, Lordship, it is not mandatory to be registered, Lordship. Now, so this self-declaration affidavit, it has to be duly executed before the competent authority. Now, competent authority would be Odd Commissioner. If there is notary in the state, so far as our state is concerned, notary has not been implemented so far, Lordship. So self-declaration affidavit or any other affidavit for that matter has to be duly executed before the competent authority. Competent authority would be executive magistrate or judicial magistrate, Lordship. Even for changing of them, it is not necessary that that has to be compulsorily registered, Lordship. Now that since that stamp paper in which that self-declaration has been made, it is numbered, Lordship. So in most of the cases, so far as our state is concerned, that registration number is not given. Now that stamp paper number, serial number is there. So through that, it can be, Lordship, it can, the competent authority can check whether the documents is authentic or not, Lordship. Now, so far as the Registration Act is concerned, Lordship.
This affidavit was required to be submitted on which clause?
Serial number 16, Lordship, page 42.
Or self-declaration affidavit. This table is part of which clause?
Lordship.
This table is part of which clause? At page 42.
42.
Serial number 16.
16, self-declaration affidavit, Lordship.
This is what? Terms and condition.
Yes, Lordship.
Lordship, page 41, Lordship.
41.
serial number para 15 lawsuit.
Yes.
The requirement of this condition is that lawsuit.
Ah.
Affidavit is required to be filed that has been prescribed on next date, which lawsuit has already seen lawsuit.
Which one? In the larger interest of public?
That is the lawsuit that the one has no
No, what I'm asking is,
lawsuit.
this serial number 1 to 24,
Correct lawsuit.
table which has been given,
Lawsuit.
this is part of which clause of the NIT?
Lawsuit itself is a closed lawsuit. The bidding documents, technical bids lawsuit. On top lawsuit will find two bids, technical and financial lawsuit. And so far this B is concerned, it's about the technical bids. What documents are to be submitted along with the technical bids? Those documents have been prescribed here lawsuit.
Now, so far as lordship condition number 15.
Why lawsuit this document at serial number 16 is required lawsuit? That has been given in serial number 15 lawsuit.
Now, lordship, serial number 15 says that, may I read lordship? In the larger interest of the public and for equitable distribution of developmental works amongst eligible contractors, and also to ensure effective management and quality of works, a contractor shall be allowed to have only 3 works in hand in any of the department under government of Arunachal Pradesh at a time, and for which he shall make a declaration to be executed in an affidavit that he is not engaged in more than 3 tender works under the state government. Now, here it says that the declaration has to be executed before the affidavit has to be executed. Now, in my case, lordship, I have the affidavit enclosed in the technical bid documents that was duly executed by the competent authority, which is Executive Magistrate Pasigat. Now, since that number affidavit, so far as affidavit number is concerned, although that may not be numbered, however, that does not change the legality of the documents, lordship. Now, since that has been executed before the competent authority, duly executed before the competent authority, so it is not mandatory as per Registration Act, Section 18 of Registration Act, lordship. It is not mandatory to be registered. Now, it does not change the validity, legality and validity of the documents, lordship, since that has been duly executed. Now, my contention is, first they have cited serial number 20, which is untenable, lordship, as per rule 4, sub-rule 2D of Arunachal Pradesh District Based Rules 2015. And since that ground, since initially they had made the ground, and after that they have added no affidavit number has been enclosed. That affidavit has not been numbered. Now, that even if it is not numbered, that does not change the legality of the documents, lordship. So the registration of the same is not required as per the provision of Section 18 of the Registration Act.
We'll close it. That day also you had agreed that once the number is there, you have no case.
Lordship, however, there is a law with regards to that, lordship. Of course, I agree, lordship. I concede that. However, Section 18 is very clear with regards to registration.
Unless there is some number to the affidavit executed in a particular office.
Yes, lordship.
How it will be verified?
Lordship,
There will be thousands of affidavits executed.
that
How they will find out?
now, of course, lordship, that is there. I admittedly, I concede that that particular that has been not numbered. However, lordship, that does not change the validity. And in fact, here as per 15, it has simply says that for which he shall make a declaration to be executed in affidavit. As per this clause 16 has come from clause 15 of the terms and conditions of the contract, lordship. And with regards to 16, here nowhere it says that it has to be compulsorily numbered, lordship. There's just bare perusal of the conditions also. It has just said that self-declaration affidavit. Number oblique, that number is in the stamp paper, Lordship. Now, with regards to registration, registration is different thing, Lordship. Registration, and as per section 18 of Registration Act, it is not mandatory, Lordship.
Have you pleaded those facts?
Lordship, that facts, Lordship, that
Mandatory directory,
submitting,
mandatory directory. Have you pleaded?
Lordship, no, Lordship, but
You are now you are changing the goalpost.
however, Lordship, that
Just now, we'll put it, we'll close the matter.
yes, Lordship, section 15, Lordship.
Hmm.
Terms and conditions 15. Here it simply says that it has to be executed.
Heard Mr. A. Tatak, counsel for the petition, and Mr. S. Tapia. For whom? Well, senior government advocate.
1 to 6 was.
You can respond 1 to 6. 1 to 6. This writ petition is directed against the letter dated 11 July 2023. Issued to the petitioner by the executive engineer, Arunachal Police Housing and Welfare Corporation Limited, word number so and so at page 125. Whoever petitioners technical bid, is not it? Technical bid. Technical bid submitted pursuant to NIT dated 10/7/2023, issued by the executive engineer, no? Executive engineer, Central Division, APH and WCL, PHQ, Itanagar, for construction of T-Roman 4, quarter 1, number at Bolen, and construction of T2, 2 quarter at Bolen, on the ground that in the bid submitted by the petitioner, serial number 20, in the bid submitted by the petitioner has not fulfilled the technical compliance at serial number 20 and no affidavit number in technical compliance 20. And the affidavit submitted does not contain any number. Full stop. In the no. What is the date of NIT?
23/6/2023.
Yes, it is not 10/7. I said 10/7/90. 23
6/2023.
Yes, 23/6/2023. 23/6/2023. No, stop. In the NIT dated 23/6/2023, issued by the executive engineer, etc. One of the requirement for compliance of the bidders as per serial number 20 of the technical bid, we can say it, no? Technical bid. This affidavit is experience certificate.
No,
Uh,
lordship.
No,
No, can you see the paragraph 15, lordship?
the,
If this is the part of the paragraph 15 only, lordship.
Hmm?
It's page 41, lordship.
Yes.
Lordship,
If lordship read the paragraph 15. the things-
page 118
Things
is the
will be very
format,
clear,
lordship.
lordship.
Page 118. It's simply a declaration that three self-declaration lordship. Page 118 is the format enclosed by the respondent.
No.
Paragraph 15 is the main requirement, lordship.
Page 41.
Page 41.
Read.
In the larger interest of the public and for equitable distributions of development works among eligible contractors, and also to ensure effective management and quality of works, a contractor shall be allowed to have only 3 works in hand in any of the department under Government of Arunachal Pradesh at a time, and for which he shall make a declaration to be executed in an affidavit that he has not engaged in more than 3 works, any tender works under the state government law.
Yes. So this clause is relatable to serial number 16,
16 laws,
not 20.
not 20 laws.
But you have rejected for non-compliance of serial number 20.
No lawship. Kindly come to the
Come to page 125.
125 lawship. The down below lawship
Yes.
have not fulfilled the technical compliance at serial number 20
Yes.
and no affidavit number in all the stamp papers. Though the lawship clause 15 and 16 has not been referred by a close name of the close lawship, but the requirement of no affidavit is requirement under the clause 15 and 16 lawship. Lawship will find in all the affidavits lawship of the petitioner lawship. None of the affidavit has the lawship number, and in 1 or 2 affidavit, even the dates are not there lawship.
What is clause 20?
Clause 20 is about the lawship, the experience certificate. lawship.
Total amount of experience.
Experience certificate. And as per the Principal Act lawship, 2015 Act lawship, in a rule lawship, it has been given lawship for class 4 and 5 lawship, experience certificate is not required lawship. So, but that part is concerned lawship, to that extent, we are lawship admitting that lawship that some error has been committed by the authority.
Did you comply with serial number 20?
20 lordship, no. Since serial number 20 does not apply to me, it's not applicable to me since I'm a registered class 4 contractor lordship.
Okay.
That has been exempted under rule 4 sub rule 2B
All right.
of the rules. And so far as that non-numbering of affidavit is concerned, lordship, para 15, serial number 15, it says that it has to be executed in affidavit. So that I have complied, lordship. Now they are coming up with this privilege ground that has not been numbered. Simply, it has been said that this section 15 and that condition, terms and condition 15 and that 16 has to be read together, lordship. It says that it has to execute the affidavit.
How many affidavits are required to be submitted?
Lordship,
Self-declaration is one.
so on perusal of lordship, the SBD lordship, the clause 15 is the only which I have found lordship. That is to be filed in affidavit
All right,
form.
all right. Then we write like this. In the NIT dated, no? And the entity date is so and so, issued by so and so. In serial number 20 of the technical bids, the bidder is required to submit total amount of experience in building construction for last 5 years, other than maintenance work certified by the authority competent to issue work order or accept tender. Full stop. Insofar as requirement of submission of the experience in building construction for last 5 years is required under serial number 20 of the technical bids of the technical bid. The petitioner contends that the petitioner being class 4 enlisted contractor under the Arunachal Pradesh enlistment of contractors. What is that?
2008 enlistment of contractor rules 2008.
Rules, no?
Yes.
Rules 2008. The petitioner is exempted from submission of such experience in building construction for last 5 years. Under which rule?
Rule 4, sub rule 2. D.
Under rule 4,
Sub rule 2.
sub rule
Roman
2,
D.
D, clause D of the Arunachal Pradesh
District based enterprise rules.
district-based
2015.
entrepreneurs
Rules 2015.
rules 2050. Full stop. The above contention raised by the petitioner has been considered by the learned senior government advocate, Mr. S. Topic, that the class 4 enlisted contractors under the 2008 rules are not required to submit such a experience certificate is prescribed under serial number 20 of the technical bid in the NIT. In view of the above, to the extent the petitioner's bid was rejected for non-compliance of serial number 20 of the technical bid of the NIT is cannot be justified. However, in addition thereto, the bidder is required to submit self-declaration, submit under serial number 16 of the technical bid.
15 and 16, Lord.
15 and 16. 15 is other card.
No, Lordship. Serial,
16 is the serial number of that table.
Lordship.
Huh?
Yes.
See,
Lordship, so far,
15 is a clause.
15 is the main clause, Lordship.
Eligibility
clause.
And
criteria.
this is the list of the document which needs to be submitted in the bid, a technical bid, Lordship.
Hmm.
Only the list is given there, Lordship.
Okay.
Eligibility criteria to participate the
Just-
tender terms and condition, Lordship.
Just
15.
then in terms of that clause 15 of the NIT as well as serial number 16 of the All right, we'll say then close 15, huh?
Yes, Lordship.
Close 15 will suffice.
That will suffice.
It is difficult to address this.
Ah,
Serial number 20. and
Better,
serial-
better close 15 lawsuit. That is
Huh?
suffice.
Ah.
Close 15, sir.
So this, whatever this serial number 20, we have said as technical bit, serial number 20 of the technical bit.
Even the 20 is the part of condition, I think,
Part of
condition.
close 15.
No, close 20, the serial number 20 lawsuit. This requirement, the experience certificate is also the part of the condition lawsuit.
Which close?
Lawsuit,
It's, it is,
Some genius have drafted these terms and conditions. And I-
so this
It's very,
basically.
it's very difficult for us to understand.
Yes, Lordship. Serial number
Yes.
15, the heading is Lordship, may I read Lordship. Eligibility criteria to participate the tender, terms and condition, page 40, Lordship. Page 40. The heading is eligibility criteria to participate the tender / terms and condition. Now, serial number 15, it only talks about for which he shall make a declaration to be executed in an affidavit. Here, there is no mention of that affidavit number. So this, after this, the condition is still 21. Now, on the next para, it's just with the heading technical bits. And even the serial number is not proper, Lordship. So we'll go by the eligibility terms and condition, Lordship.
However, under clause 15. Of the NIT that is so and so. The bidder is required to submit a declaration executed in an affidavit that he is not engaged in more than 3 tender works under the state government. Full stop. You add inter alia. The next ground on which the petitioner's bid has been rejected by the appeal letter dated 11 July 2023 is that in the declaration made by the petitioner by executing an affidavit that he is not engaged in more than 3 tender works under the state government does not contain number of the affidavit. Full stop. Challenging the opposite ground for rejection of the petitioner's bid on the ground of of the affidavit submitted by the petitioner not containing any number. The petitioner has contended that in the similar affidavit submitted by the respondents 7 and 8,
Yes, Lord.
private respondent number 7 and 8 also did not contain number of the did not contain the affidavit number, and therefore the petitioner has been treated differently than the respondent number 7 and 8. Also, it was in the light of the above contention that this court by an order dated 24/7/2023 had directed the senior government advocate to produce the original records containing the affidavit submitted by the petitioner as well as the respondent number 7 and 8 also. The original record containing the aforesaid affidavit has been produced by the senior government advocate, which has been perused by this court. On perusal of the affidavit submitted by the petitioner as well as the respondent 7 and 9, it is noticed that in the affidavit submitted by the petitioner, the said affidavit does not contain any number, whereas in the affidavit submitted by the respondent number 7 and 8, contains number assigned by the office in which the said affidavit was executed. Also, in that view of the matter, the contention raised by the petitioner that the petitioner has been treated differently than the respondent number 7 and 8 cannot find favor from this court. Also, since the self-declaration by the bidders in the form of an affidavit stating that he does not have more than 3, what was the language?
3 tender works, ongoing tender work,
3
more than 3 tender works under state government.
that he is not engaged in more than 3 tender works under the state government is one of the requirement of the NIT. Any affidavit submitted to that effect by the bidders, therefore, must indicate that the said affidavit is an authentic one. The authentic one also. It is for the opposite purpose that that numbers have been assigned in the affidavit executed before the before the magistrate or before the appropriate authority, and in the instant case before the magistrate. Full stop. In the instant case, the affidavit submitted by the correspondent number 7 and 8 being numbered, they having been assigned a number by the authority where it was executed. The respondent authorities accepted the said, appears to have accepted the said affidavit as authentic and genuine and submitted in the authentic and genuine poster. Whereas poster. And in the case of the petitioner, in the case of the petitioner, while the affidavit submitted by the petitioner did not contain any number assigned by the authority where it was executed, the respondent authorities appears to have not believed the affidavit submitted by the petitioner to be authentic in the absence of a number assigned by the authority where it was executed, and thus appears to have been rejected on that ground. Full stop. Since the view taken by the respondent authorities in not accepting the affidavit submitted by the petitioner for want of the number assigned to it by the office where it was executed, being found to be a reason, it is found to be a plausible reason for rejecting the bid of the petitioner on that ground. I'm of the view that no interference is called for to the impugned letter dated so and so 11 July 2023, issued by the Executive Engineer Center Division APH and WCO PSQ to the petitioner by number so and so. Also, read petition accordingly since disposed of.
Lordship, may I pray that I have also raised certain, I have also made a specific averment that there is no clause in the instruction to bidder where it says that the affidavit in stamp paper has to be numbered. Para
Mr. Tatak,
para 10.
if there are
Grounds.
other contentions raised,
Yes, Lordship.
then we'll issue notice. Because as far I remember,
Yes, Lordship.
on the last occasion, you had said
Yes, Lordship.
your only contention was that the affidavit submitted by them also,
Lordship.
respondent also does not contain number.
Yes, Lordship. I concede to that extent. Lordship.
So you can't be treated differently than it was for
Yes.
that purpose. Otherwise, we will call for an affidavit.
Lordship,
If there are other contentions raised.
Lordship, along with the grounds, I have also raised that this particular, there is no particular clause where it says that that particular affidavit has to be numbered on the last occasion itself, Lordship. And then among other grounds.
What is that? What is that? pleading?
Para 10, Lordship. Page
Para
page
10.
6, page 14, grounds for challenge amongst other grounds. That it is at page 16, Lordship. Page 16.
Page
P. May I read, Lordship? Page 16. C.
Yes.
Grounds number C. That there is no clause in the instruction to bidder of the NIT dated 23/6/2023, where it says that bid of a petitioner
All right.
would be rejected.
Then we'll issue notice, call for the affidavits.
Lordship.
Okay.
So since from a bare perusal of Lordship condition eligibility criteria number 15, it only says that it has to be executed. It has to be duly executed.
All right. Had Mr. I, Council President, and Ms. Estabin for respondent 1 to 6. Issue notice. Returnable in 4 weeks. Steps for service notice upon respondent number 7 and 8. But register process AD as well as the usual process within a week. Full stop. Pursuant to order dated 24/7/2023, Mr. Tapin Lamid, Senior Counsel, Senior Government Advocate has produced the original record which contains the affidavit submitted by the respondent number 7 and 8. In the bids submitted pursuant to NIT dated 23/6/2023 issued by the Executive in the Central Division, AP and WCL except PSQ. Return by number so and so. It is already there in 24/7. Upon perusal of the number, upon perusal of the affidavit submitted by the respondent number 7 and 8, it has been found that the affidavits of the respondent number 7 and 8 have been assigned number, whereas the affidavit submitted by the petitioner has not been assigned and assigned any number by the office where the same was executed. Full stop. In that view of the matter, the status quo order passed on 24/7/2023 is not extended. Listed after 4 weeks.
Deeply obliged.
All right.
May I please? My lord, by way of this petition, my lord, the petitioner praying for setting aside and quashing of appointment orders. There are a series of orders, my lord. Altogether 6 orders, my lord, for the post of junior engineer, my lord. Among the 6 posts, my lord, 2 posts are of regular junior engineer, my lord, and 3 posts are of contractual junior engineer, my lord, civil, and 1 is of draftsman grade 2, my lord, in the engineering wing of education department. My lord, the appointments of these private respondents, my lord, 3 to 8, my lord, were made, my lord, by not adhering the recruitment rules, my lord, applicable to the post. So the petitioner being an eligible candidate, my lord, eligible for the post, my lord, when he came to know about the occupation of these posts, my lord, as being appointed without following the recruitment rules, he applied for RTI and obtained the documents. My lord, may peruse page 51, my lord, is the recruitment rule.
When were they appointed?
My lord, they were appointed on series of, on different dates, my lord, from 2017 to 2019, my lord. That is annexure 3 series, my lord, page 44. Is the
Page
44, my lord.
44.
This is the appointment order of private respondent number 3, my lord. My lord, initially, private respondent number 3 was appointed as draftsman grade 2, my lord. Thereafter, in the page 45, my lord, will find at page 45. By redesignating the post of draftsman grade 2, my lord, the respondent authority has redesignating the post of draftsman grade 2 as junior engineer, my lord. He was regularized to the post of junior engineer, my lord, in the year 2019. Thereafter, my lord, annexure 4, page 46 is of the respondent number 4, my lord, private respondent number 4 is of regular junior engineer. And thereafter, annexure 5, my lord, page 47, page 47 to 49, my lord. On same date, these respondents were appointed as contractual junior engineer. And at page 50, my lord, at annexure 6, my lord. This is, my lord, of appointment of draftsman grade 2, my lord. So all these appointments were made, my lord, without any publication or advertisement to the post, my lord, and without in conformity with the recruitment rules. May I take, my lord, to recruitment rules?
How many private respondents?
So there are, my lord,
5.
6, my lord.
1, 2, 3, 4, 5. Okay, 6.
6.
Yes. Where is the rule?
Yes. My lord, recruitment rule for junior engineer, my lord, that is junior engineer civil group C, my lord, 1994. It starts from page 51, my lord, annexure 7. My lord will find the mode of appointment at page 53, my lord. Matter of recruitment, my lord, at column 11, my lord.
This applies to education department.
Education department, engineering wing. So these recruitment rules were procured by the petitioner through RTI from the department itself, my lord. That is, my lord, will find at clause 11, 95% by direct recruitment, my lord. Out of which certain reservation is there for APST and for the general candidates, my lord. And 5% by promotion. That about, my lord, there is a separate recruitment rule for draftsman grade 2, my lord.
Who is draftsman?
Draftsman, private respondent number
4.
No, my lord, 8, my lord.
8.
8.
Okay.
My lord, annex.
All others are junior engineer.
Yes, my lord. My lord, may I take, my lord, to annexure 8, page 55, my lord?
Yes.
The mode of appointment, method of appointment for recruitment for draftsman grade 2, my lord, is at page 56, my lord. Here, my lord, we'll find it column 10, my lord, that is 50% direct recruitment from the select list prepared on the basis of written competitive examination. My lord, there were no written competitive examination ever held for this post, my lord, followed by viva voce. And that apart, my lord, there is a separate guidelines issued through gazette notification for the appointment of contractual employees, my lord, in the state of Arunachal Pradesh, which is clearly says, my lord, that in case, even in case of exigency of service, my lord, there has to be a wide publicity for the post, my lord, which was not carried out by the department. So by way of this application, my lord, petition, my lord, the petitioner is praying for interference of this honorable.
Yes. Yamu?
My lord, I have seen this RTI information given to the petitioner also. And I have spoken to this department also regarding this. Obviously, my lord will first ask me whether there was this advertisement and mode of selection. Your lordship will, in such cases, your lordship will first of all ask that to me. So it is clear in this page 42, my lord, that department has clearly said in their RTI that there is not available, such records not available. And I have asked to them also. But my lord, one thing I would like to submit before this honorable court. Such matters comes a lot in this court, my lord. In our event, such matters comes a lot. And my learned brother is seeking for a stay order of the appointment order made in 2017 and 2019, my lord, in the absence of not hearing this private respondents here, my lord. Such matters, my lord, comes in this high court, my lord. Countless cases has come. So I cannot say at this stage that their appointment were made regularly through some accepted mode of selection, my lord. But it is also a fact that we cannot take such matters very seriously also in context of our bench. Such cases comes and withdrawn in time, my lord. It is a fact, my lord. And I am making this submission before this honorable, learned bar, my lord. In presence of them, I'm making this. Such matter comes and withdrawn in due course of time, my lord. So I want to place in record that.
All right.
Yes, my lord.
We'll issue notice.
My lord, yes. Interference at this stage might hamper the functioning, my lord. It may be left to the outcome of the final hearing, my lord.
All right.
My lord.
Mr. K. Dubey, learned counsel for the petitioner. Mr. T. Jamin, learned standing counsel for the Education Department representing respondent number 1 and 2.
1 and 2.
Issue notice, returnable in 4 weeks. Jama accept 1 and 2 extra copies. The steps for service of notice upon respondent number 3 to 8 be taken by registered post with AD as well as the usual process within a week. Dusty in addition is also permitted.
My lord.
If you want quick disposal of the case, you may take Dusty also.
My lord. I leave.
We'll come back after 5 minutes.
Okay, my lord.
My lord, this is second round of writ petition, my lord. Earlier, it was filed for declaring DPC result, and later pursuant to this order, they have placed the instruction wherein say that subsequent DPC has been taken place. Now, my lord, I'm challenging the subsequent DPC and the follow-up action taken by the state respondent. My lord, here, the private respondent 5, 4 and 5, they are illegal appointees. And after illegally they were appointed, they were illegally regularized without conducting any selection process. Now, the petitioner, my lord, he was appointed as a SK supervisor in Kanungo after conducting through recruitment process by conducting a competitive examination, follow the BEVA ways, my lord. He was appointed on 24 August 2009, my lord, at page 80, my lord. Type copy is 81, my lord. He was appointed. Type copy is 81, my lord. Petitioner's name appears at serial number.
There was a DPC earlier which recommended your name.
Yes, earlier it was recommended my name.
Which is the DPC?
My lord, it is at, my lord, to see at page 143, my lord.
Dated?
Dated 18 October 2012, at 22, my lord.
18 October
Yes, 2022.
22.
Yes,
Your name was recommended.
yes.
Then what happened?
Thereafter, my lord, my name, my lord,
Sorry, promotion to which post?
promotion to DLRSO, my lord,
DLR.
from ASSO,
Assistant?
Survey and Settlement Officer, to District Land Revenue and Settlement Officer, my lord.
Okay.
My lord,
Then that was not acted upon.
yes, that has not been acted. Subsequently, my lord, after lapse of 8 months, although DPC was held, my lord, on 18 October 2022, and the out of the DPC committee, my lord, out of 3, 2 has signed in minute, recommending the petitioner for promotion, my lord.
Yes.
Now, thereafter, the chairman, secretary did not put the signature, and matter kept on pending, my lord, without notifying result. And after 8 months of lapses, my lord, after 8 months, I approached this honorable court that there's an inordinate delay on part of the respondent not declaring the DPC result. Then pursuant to the direction issued by this honorable court, my lord, in WPC 288 of 2023, my lord, on 13 July 2013, my lord, the instruction was placed wherein it say that the earlier 18/10/2022 that was not conclusive, And subsequent DPC was held on 23 June 2023, my lord. This was the, on having come to know, my lord, this subsequent development, I withdraw that part, that the previous writ petition with liberty to file a fresh, my lord. And after withdrawing I obtained all the document through RTI. And now through RTI, my lord, it's found that what they did, my lord, subsequently, on 18 October 2022, my lord, the DPC is at page 45 to 46, my lord.
Kamduk will examine.
Yes, Lord. Sir.
In the meantime, don't give effect to this 23/6/23. No urgency.
Lord. Sir.
Is not it?
Lord. Sir.
No. Add Mr. T. Thakur, counsel for the petitioner, Mr. D. Kamduk, the standing counsel for the Environment Department. Representing respondent number. P. Pangupur 1. Why have you met Chief Secretary?
Chief Secretary, my lord, actually, there was a direction, my lord, this the notification, redesignation, my lord, that's issued by Chief Secretary, my lord. There's a order. That's why, my lord, he has been made the performer responsible.
Okay. You should notice. We come look for 2 and 3. You should notice. Returnable in 6 weeks. As for the accepted notice, no follow notice, extra copy. Distress for service of notice upon the respondent number 4 and 5 be taken by registered subsidiary as well as the usual process within a week. In the meanwhile. Minutes of DPC meeting held on 23/6/2023. Shall not be given effect to.
In respect of both DLRSO as well as
Still, returnable date, Lord.
Just a moment. Where is the DPC? Yeah, so where is
my-
that proceeding?
my lord, proceeding is at my lord, see at page 37, my lord. No. DPC at my lord will see page 53 to 54, my lord. 53 onward, 153, my lord.
153.
Yes, my lord. 153 type copy, my lord. Recommendation part is in respect of DLRSO, my lord. Page 55, my lord. 155 is recommendation. Instead of my place, my lord, this private respondent illegal appointee's name has been recommended, my lord. Page 155. And thereafter, my lord, having withdrawn my name on same day, my lord, again at page, my lord, see 166, my lord, to 167. My earlier promotion, regular promotion, which was done 2016, my lord, after 7 years, again that has been recommended to be withdrawn to the post of ASO, my lord, at page 167 on same day, my lord.
Both are under challenge.
Yes, both are under challenge.
That is review departmental.
Yes, in respect of ASSO.
Just in the review DPC, what has been done?
My lord, in review DPC, my lord, my promotion to the post of ASO from SK to ASO, which was done after conducting proper DPC, and that is 2016, it was done almost 7 years back.
2016. Okay.
Yes, and that was sought to be revoked.
Okay, that has been reviewed and you have been sent back as SK.
SK, my lord, and that has not yet been implemented, my lord. They recommended for revocation. My lord.
Then this at page 153.
153 is in respect of DLRSO, my lord. Because DLRSO by 18 October 2022, my name was recommended for post of DLRSO.
Two of the private respondents have been recommended
Yes,
for DLRSO.
yes,
Both of
subsequent.
them.
Yes,
Both of them.
yes,
Okay.
in place of my place.
Till the returnable date. Huh?
Yes,
Till
sir.
the returnable date. Minutes of DPC meeting held on 23/6/2023. Annex 33, whereby respondent number 4 and 5.
Yes.
Respondents number 4 and 5 have been recommended for promotion to the post of DLRSO. And the minutes of the review departmental promotion committee meeting
Yes.
held on same date,
Yes, same.
23, whereby the petitioner has been reverted from ASSO
To
to
SK.
SK.
Yes.
Shall not be given effective.
My lord.
List it after 6 weeks.
Deeply aware.
Met, please, Lordship.
Hmm.
My lord,
Unaccepted you do last week. Yes.
my lord, in this writ petition, my lord, the petitioner is claiming for, my lord, the pending bills, man. The petitioner, my lord, has, my lord, executed the construction of PMGs via road, my lord.
What is the admission?
My lord, that is, their own, my, come to my annexure 5, page 31, man.
Page 31.
Yes.
Yes.
Yes, this is the, my lord, prepared by the executive engineer, man. Bombing division.
Yes.
And here, my lord, he has requested the chief engineer to release the amount, man, because PMG's by, my lord, money is already with the department money, central government sponsored money. So, my lord, earlier what had happened, my lord, because of some complaint, there was an inquiry, my SIC inquiry, man. Now that SIC inquiry, the closure report has been given, man. I've annexed that one, man. Kindly.
Hold on. Yes. What do you say?
Let me take instruction
whether
this.
You appear for all.
Yes, 1, 2,
Okay.
3.
Suppose for petitioner and product for art. Notice 4 weeks. Next go.
Oblige.
Yes.
My lord, my lord was right so far, my lord, when I argue on the point of legitimate expectation and promissory estrangement, I am not arguing to this to consider. My case, my lord, I will based on section 70 of the Indian Contract Act. Section 70 says, my lord, so far some work has been done, my lord. That is the admitted position, my lord. There is no dispute, work has been done. They have used it. The government has used it, that work, my lord. And my lord, section 70 says, my lord, when any such thing act has been done with the intention that that has not been done for gratuitously, my lord, then the beneficiary of such work, my lord, though it may be the government, my lord, is liable to compensate, my lord. So that is the principle of law. Here, so far, my case is concerned, my lord.
For that also you will have to file a suit.
No, my lord. So far, my lord, writ petition is maintainable, my lord. Some judgment recently, I think this.
No, we are not saying that it's not maintainable.
My lord.
It is maintainable.
My lord.
But on merit, you will have to go to the. Civil
There
court.
is, my lord. Well, there is certain judgment where my lord has under 226, my lord, this principle has been invoked and direction has been issued to the state government to pay the compensation, my lord. So far, my lord, there is no dispute over the work is concerned, my lord. So far, the execution work is concerned. Here, my lord, and moreover, my lord, here is the question, my lord. So far, admitted position is there, my lord. So far, respondent number 4, who was the executive engineer. My lord. So far, executive engineer, my lord, what happened at that time, my lord? Tourism department did not have its own engineering wing, my lord. So tourism department used to carry out the work through the RW, Department of RW. And my lord, in 2008 and 9, my lord, I was 2008 and 9, my lord, I was awarded the contract work, my lord, the construction of a tourist lodge and tourism car parking area at Gangaland. I carried out that work, my lord, under the supervision of the executive engineer, the implementing agency, my lord, the RWD. So during the execution of that work, my lord, the executive engineer, respondent number 4, my lord, that fact has not been denied, my lord, because respondent 4 has not filed even an affidavit, my lord, contributing my particular statement, my lord. During the execution of the contract work, respondent number 4 categorically asked me that you carry out this additional work. He has a category permission from the
Respondent number 4.
4, my lord.
Who,
My lord, I
who is he?
take to paragraph, my lord, kindly take
Who-
to paragraph,
Who is he?
uh, page number 7 of my read petition, my lord. Page number 7,
Yes.
E, my lord.
Ah.
My lord. After the construction of the above sanctioned infrastructure, the respondent authority number 4, Mr. Engineer Toko Ilto, was then serving in the said post, who was in charge of the, directed the writ petitioner to further carry out the additional contract work. Development of essential infrastructure in the basement area of the already constructed tourist car.
Government contract work can be awarded in this manner.
No, cannot be. So that's why, my lord, I am not on the point that legally.
He himself, he will be liable to pay you
No, my lord.
from his pocket.
No,
not from
my
the
case,
government.
my case is a different.
Yes.
The law says, my lord, here is not the position of, I am not claiming on the basis of that there is a valid contract.
Mm.
So far, my lord.
Yes.
I'm not, my case is not on the basis that there is a valid contract. My lord, to be a valid contract, of course, certain legal requirements are required, my lord.
Mm.
So here is the case, my lord,
Mm.
that what I am trying to say is, my lord, when this particular person, my lord, who was the, my lord, executive agency, he asked me to construct the work, additional work, my lord. I constructed. My lord. Now the law says, my lord, that even though maybe there may not be any contract, my lord, or even though there may not, the contract may be illegal or invalid, it has not been done in the manner that the Article 299 of the Constitution says that any contract, whenever in the name of the government, it has to be executed in the name of the government. Series of decision is like that. Contract may be illegal. Government might have not approved. The question is that principle always remains that principle of unjust enrichment. Now you have been using this property, which I have, by putting my hard-earned resources, I created. You did not deny this one. And here in this case, what happened, my lord? Director Tourism, when this report was submitted to the Director Tourism, saying that he has executed the work, then Director Tourism also asked its own engineering department to verify the construction work. So my case revolves around, my lord, only on the basis that section 70, that the government cannot take unjust enrichment because, my lord, after 13 years, they have used their assets, my lord. Now government cannot say, my lord, that after having used my asset because contract was not valid.
We can put it slightly differently.
My lord.
What kind of work you have done here?
My
What kind of work you have done here?
Additional, well, here, my lord, what happened? First,
Additional,
I was provided this construction of tourist laws.
Tourist laws.
In the basement area,
Where?
this Gangale.
Gangala.
Gangale. So in the base, may I show, my lord, this additional work?
See, you were asked to construct tourist laws.
Yes.
There was a work order.
Yes.
All right.
Yes.
After that work was executed by you, which is a valid contract,
Yes.
given by the state,
Yes.
is not it?
Yes.
Now this officer, who is that officer? The director to-
Executive engineer, RWD.
Executive engineer RWD. He asked you to construct an additional work,
Yes.
which does not have the approval of the government.
Yes, I admit.
Correct.
Yes.
Now, at the instance of this executive work in his personal capacity,
Yes.
you have carried out an additional work
Yes.
in the government premises, which the government did not require it.
No, here is the catch point, my lord.
See,
I
it's
will
not,
come.
You see.
Law says differently.
You have forcefully constructed this
No,
something
not
which,
forceful.
see, which the government does not require.
No.
If not forcefully conspiring with the executive engineer.
No. No.
Executive engineer acted in his personal capacity. You sue him for your damages.
No, law says differently.
no,
my lord.
no,
Such similar cases have been decided, my lord. Law says differently. Government had the option,
If you
My lord.
argue in that line,
my lord.
we may see there is order dictated in this matter on the last occasion.
My lord,
If you argue in that line,
my lord.
we may held the writ petition to be not maintainable.
That's my lord, what
What is
decision,
your
my
legal
lord, my
right?
lord will,
Yes.
that's up to my lord, what decision my lord will
All right,
pass.
all right.
I don't have control over that. My lord.
Yes.
Only what I am trying to say,
Hmm.
that there are certain laws, section 70, that favors my case. And I'm trying to,
Let us look at section 70.
my lord. There are a series of
Section
70 of the Indian contract.
Okay,
There
yes.
has been,
That can be enforced by way of a mandamus.
my lord, so many judgments are there, my lord, that has been enforced, my lord.
All right, let us see. Obligation of person enjoying benefit of non-gratuitous act.
Here, my lord, the formulation of law, my lord.
Where a person lawfully does anything for another person.
Yes, my lord.
For whom you have lawfully done.
My lord, so far this thing that the carrying out the work, my lord. Carrying out the work, my lord. This has been,
For whom?
this,
You have carried out the work for whom?
I have carried out at the instruction of the government, my lord.
No, by
No,
the,
okay, okay, at the instruction of this executive engineer. My
yes,
lord. At the instruction of the executive engineer.
yes.
Now the court has said in series of judgment, my lord, that such execution of work can be constituted lawfully, my lord. Though there may not be approval from government may not know anything, but catch point is here not that, my lord, whether approval was there. Question comes subsequent, my lord. The law, Apex Court has discussed these issues and our own Honorable High Court has also discussed this issue. The question here comes, my lord, once I have constructed, maybe, my lord, without approval, but lawfully in the sense, my lord, that executive engineer asked me to do, I have done it. Now the problem here lies, my lord.
He had no authority
My lord,
to.
that's why I concede. But the law says that not require of authority. Forget about authority. Law says, my lord. The law is saying, government, you had the option when you came to know that this has been constructed. You should have said it. We are not going to take it. This representation has to be given by the government. A specific statement has to be made by the government. We will not use it. Since without approval, without authority, you have constructed.
If you forcefully construct on the premises of a government,
No, forcefully. My lord.
conspiring with the executive
No,
engineer.
my lord, this is
Huh?
not the case, conspiring, my lord. The matter, my case is not at that point. Government
They,
has not declined to use my property. Government has used it, my lord, for more than 13 years. Government have earned revenue from my construction. My case is on that line. The section 70 is against basically principle of unjust enrichment. Long time back, my lord, 1962, this principle has been settled in so far our jurisprudence is concerned, taking into consideration the law of other nations, my lord, American jurisprudence, UK jurisprudence. Our Supreme Court has said,
what
that
is the jurisprudence?
my lord, principle of unjust enrichment.
Yes,
A person cannot take the benefit. Maybe the work has been gratuitously done by others. Suppose, my lord, I will give one example. I, without any having intention to give gratuitously to anybody, I kept certain thing in a person's home.
anyway,
Now-
you conclude your argument.
My-
Our judgment is ready.
My lord,
Yes.
my lord will not go by the judgments which says section 70.
See, that is up to you.
My lord,
Whatever you want to place it, place it.
okay. I will place, my lord. I will place it.
Yes.
So section 70 says that once you have used it,
Hmm.
you have not rejected it. Now my case premise on that point only.
Hmm.
There is no dispute so far. Work has been carried out, my lord. No dispute. This is admitted position, work has been carried out, my lord. Now, my lord, I will just, my lord, rely on some citations, my lord, where certain issues have been raised, my lord. First, my lord, this AR 1962 BK Mandal case. Just give the paragraphs, my lord can go through it.
BK Mandal.
BK Mandal. Here, this particular principle of unjust enrichment and section 17 has been elaborately dealt, and my lord's query specifically,
BK Mandal.
state of West Bengal
What
versus
is
BK.
this audio? Audio in one wrong.
In this case, my lord, particularly my lord's the question, the query put by the my lords that whether government without approval at the act of the official consent, that out of his own official consent, he gives my
BK Mandal is for the proposition.
for the proposition section 70.
If any authority of the government enters into an agreement
My lord,
with the contractor,
my lord.
not in the name of the governor,
Yes, yes.
huh?
Yes.
It will not be binding. Here, what to talk of the in the name of the governor? There is no any contract at all.
Oh, my lord, my lord, my lord, my lord, will pause. This judgment.
Yes.
says- This judgment says,
What happened to this audio?
this judgment says you don't require, not necessary that any contract has to be given. Section 70 is based on not contract. This is on the principle of equity, my lord. That principle of unjust enrichment is there, that when a person has not done any work gratuitously, the person who has taken the benefit, he cannot deny the payment of compensation, my lord. This and my lord's query especially, that a government official without authority, if he enters contract and the work is carried out and the government takes the benefit, what will be the consequence, my lord? This has been discussed in this judgment, my lord.
Yes.
Paragraph, my lord. 13 to my lord. I think this was constitutional bench judgment, my lord. First time this issues was formulated in this case, my lord, about the section 70. And the same issue, my lord, similar case. Here in this case, what happened, my lord, that on the instruction of the government official, additional work of construction of warehouse was carried out, my lord, without any valid contract, without anything, my lord. Then the matter went to the Supreme Court, my lord. Then this question arose in this case. The same, the my lord has asked that whether they are being without any prior approval of the government, can section on the basis of section 70 compensation can be claimed. The constitutional bench says yes, section 70 doesn't base on any contract. It is the principle of equity based on the principle of unjust enrichment, that a person cannot take the benefit which other person has not done gratuitously. And here the my lord illustration has been given. Government should say, if government comes to know, my lord, that the property has been work has been executed without permission, my lord, government has to say.
Does it also say that in such a case, liability will be of that person concerned, officer concerned,
No,
not the government?
government. It says that government. Why?
Where
Because
is that?
government has used the property.
Where is
Government has
that?
taken the benefit, my lord.
Where is that?
My lord, let's start from paragraph 13, my lord. Similar nature of case, my lord. Long judgment, my lord, because for the first time this issue was formulated and discussed, my lord. Paragraph 13, my lord. It says about what is section 70. Then 14, my lord. It is plain that three candidates, my lord, may I read? Or my lord will go through. Long paragraphs are to be required to be read, my lord.
Which paragraph?
I will start from para 14, my lord. It's a very long paragraphs, my lord.
Where it is said that the government will be liable?
My lord, I will give. My lord, paragraph 19. Paragraph 19, my lord. I will paragraph 19, 20, all issues have been discussed, my lord.
Yes.
In regard to the claim made against the government of a state under section 70, it may be that in many cases, the work done or the goods delivered are the result of a request made by some officer or other on behalf of the said government. In such case, the request may be ineffective or invalid for the reason that the officer making the request was not authorized under section 175 so and so, or if the said officer was authorized to make such said request, the request become inoperative because it was not followed up by contract executed in the manner prescribed by section so and so. In either case, the thing has been delivered or the work has been done without contract, and that brings in section 70. A request is thus not an element of section 70, and although the existence of an invalid request may not make section 70 inapplicable. An invalid request is in law no request at all, and so the conduct of the parties has to be judged on the basis of that there was no subsisting contract between them at the material time. Dealing with the case on this case, we have to inquire whether the requisite condition prescribed in section 70 have been satisfied. If they are satisfied, then a claim for compensation can be and must be entertained. In this connection, it is necessary to emphasize that what section 70 provides is that compensation has to be paid in respect of the goods delivered or the work done. The alternative to the compensation thus provide is the restoration of the things so delivered or done. In the present case, there has been no dispute about the amount of compensation, but normally a claim for compensation made under section 70 may not mean the same thing as a claim for damage for breach of contract, so and so. Thus considered, it would be, we think it not be reasonable to suggest that in recognizing the claim for compensation, we are either directly or nullifying the effect of section so and so. The field covered by two provisions are separate and distinct. Section 70 deals with the contracts and provides how they should be met. Section 70 deals with the case where there is no valid contract and provides for compensation to be paid in case there where three requisite conditions prescribed are satisfied. We are therefore satisfied that there is no confusion. Para 20, my lord. It is well known that in the functioning of the vast organization represented by the modern state government, officers have invariably to enter into variety of contracts which are often of a petty nature. Sometimes they have to act in emergency, and on many occasions in the pursuit of the welfare policy of the state government, officer may have to enter into the contract orally or through correspondence without strictly complying with the provision of section so and so. If in all these cases, what is to be done in pursuance of the contract is for the benefit of the government and for their use and enjoyment and is otherwise legitimate and proper, section 70 would step in and support a claim for compensation made by the contracting parties, notwithstanding the fact that the contract had not been made as required by section 175. It was held that if it was held that section 70 was inapplicable in regard to such dealings by government officers, it would lead to extremely unreasonable consequences and may even hamper, if not wholly bring to a standstill, the efficient working of the government from day to day. We are referring to this aspect of the matter, not a view to distract from binding character of provision of section so and so, but to point out that like ordinary citizens, even the state government is subject to the provision of section 70. And if it has accepted the things delivered to it or enjoyed the work done for it, such acceptance and enjoyment would afford a valid basis for claims for compensation against it. Claims based on a contract validly met must therefore be distinguished so and so. So, my lord, in this case, my lord, other aspects have been described wholly, my lord, saying, my lord, it is not on the basis whether the contract has been properly,
Yes,
my lord, executed, not issued at all. The entire, my lord, premises is that once work has been done,
yes.
if the government, because in this case it says that the option was given to the government. If government thinks, my lord, no, this has been done illegally without my consent, and we don't want to use this thing, the court is saying that government has the option, saying that we will not use it. Then at that time, my lord, the contractor will be at risk, my lord. Will be at risk. At that time, I would not have any right to claim compensation against. But here in this case, my lord, government conceded, use it, and now is still using, my lord. So, considering all this aspect, my lord, this is principle of unjust enrichment is like that. You cannot take the benefit of somebody's work. And after using it, you cannot say that I did not request you. Illustration given is, my lord, if I keep some things in my friend's house with not the intention to give that friend gratuitously, Tomorrow, my friend used that property, my lord. Law says he is liable to pay compensation for me. My lord. Same principle has been, my lord, made applicable to the government also, this constitutional judgment, my lord. Here, my lord, so long judgment, all these aspects have been discussed in this, my lord. Relevant, my lord, paragraph, my lord, from 13 to, my lord, 24, then 27, 42, 43, 44, and 46, my lord. But ultimately, my lord, the precedent, the ratio of the judgment is that if you have used it, not rejected, then you are liable for the compensation.
Yes.
My lord. Then, my lord, I will come to our own High Court judgment, my lord. 2023 GLR, my lord, Justice Ujjal Bhoya passed by the, my lord. Contractual matter, my lord. In writ jurisdiction, my lord, this judgment has been filed. 2023 GLR.
Yes, you may read it slowly.
My lord, GLR, my lord, 2023 400, 2023 GLR, para 17. Here in this, so my lord, what happened? Without the approval of the government, director awarded contract work. This 2020 GLR. Work was carried out. When the claim was made, government says that no approval, nothing. But in this case, my lord, so far the work was, whether the work was done or not, that was not clear. That's why the Honorable High Court, single bench of this Honorable High Court, invoking Section 70, constituted a high power committee saying, forget about the validity of the contract. You make the verification whether the work has been carried out or not. And if the work has been carried out, government has taken the benefit. The action has to be taken consideration Section 70 of the contract. This particular judgment, my lord, paragraph, I will start on paragraph 77, my lord. This 2020 JLR, my lord. At this stage, Section 70 of the Indian Contract Act may be adverted to it. Section 70 says that where a person lawfully does anything for another person or delivers anything to him, not intending to do so gratuitously, and such other person enjoys the benefit thereof, the latter is bound to make compensation to the former in respect of or to restore the thing done or delivered. Thus, on a careful reading of Section 70, what is evident is that claim under section is for compensation. But for payment of such compensation, three conditions must be fulfilled. Firstly, the thing or act must be done lawfully. Second, it must not be gratuitous. Lastly, the person who is called upon to make the must enjoy the benefit of the act or thing on the basis of so and so. Para 78, my lord. BK Mandal case has been referred here, my lord. Constitution bench judgment of this Supreme Court in so and so is the leading decision on this provision. Supreme Court held that the above three conditions must be satisfied before Section 70 can be invoked. Elaborating the rationale behind Section 70, Supreme Court held that if the goods delivered are accepted or the work done is voluntarily enjoyed, then the liability to pay compensation for the enjoyment of the said goods or the acceptance of the said work arises. Thus, where a claim for compensation is made by one person against another under Section 70, it is not on the basis of any subsisting contract between the parties. It is on the basis of the fact that something was done by the party for another, and the said work was so done has been voluntarily accepted by the other party. Of course, Supreme Court clarified that between the person claiming compensation and the person against whom it is claimed, some lawful relation must subsist. Explaining the implication of the lawfully as appearing in section, Supreme Court held that after something is delivered or something is done by one person for another, and that the thing is accepted and enjoyed by the debtor, then a lawful relation is born between the two, which under Section 70 gives rise to a claim for compensation. Well, the moment my work is enjoyed by the government, then lawful relationship is automatically established. Regarding claim against the government of a state under Section 70, Supreme Court held that an invalid request in law, no request at all. And so conduct of the parties has to be judged on the basis that there was no subsisting contract between them at the material time. Supreme Court finally concluded that the Section 70 deals with cases where there is no valid contract and provides for compensation to be paid where the three requisite conditions prescribed are satisfied, thus operating in a field separate and distinct from section so and so. Para 79. Upshot of the above discussion is that the contract agreement signed by the director handloom so and so are not valid as the condition under so and so have not been satisfied. So also the requirement of rule so and so so. On the other hand, those contract agreements signed by the agency with the cannot be the basis of any claim by the supplier against the government, there being no privity of contract between. Therefore, Article 29 would rule out any payment by the government to the supplier on the issue. That brings Section 70 of the contract into the picture. While certainly supplies were not made by the petitioner graciously for a lawful relation to be established between the petitioner and the state, it is required to be ascertained as to whether the goods or blankets were accepted and enjoyed by the latter. A decision has to be taken by in this regard. So in this case, my lord, about the work, there was no clarity. That's why my lord saying that government is liable. Only you now verify whether you have it. But my case is slightly different, my lord. Now they have accepted the work, they have enjoyed. There is no dispute so far. That part is concerned, my lord. So in writ jurisdiction also, my lord, this our own High Court Section 70 invoking liability has been held, my lord. Just my lord, recently, my lord, this June 12, my lord, our single bench of our own Honorable High Court, my lord, this last month only, my lord, again relying on this judgment, my lord, 2000. Yeah. My lord, para 21, my lord.
Yes.
This is Justice Mehdi, my lord. Para 21 onwards, my lord. 25, my lord. All this Section 70 discussion has been done, my lord. Here also what happened, my lord? This subcontract, the main contract with the contractor that was already rescinded by the government, my lord. Now the court says, no, the subcontract has done the work and you are not disputing the work. Now you are enjoying the benefit. Then you must pay them the money, my lord. Irrespective of the question whether the contract was valid, not valid, those because Section 70 is in a different realm altogether, my lord. So this judgment, my lord, our own court, my lord, division bench judgment, my lord, division bench judgment 2009 4 GLT, my lord. Here, my lord, in 2009 4 GLT, my lord, para 21, 31. Paragraph 21 and 26. In this case also, my lord, what happened? The single bench held that the contract awarded to the PDS contractor was illegal, man. But what happened in this case? That the work was executed. Okay, PDS work was executed, government took the benefit. Then the matter went to the division bench. And division bench again invoked Section 70, saying that the contract may be invalid, contract may be wrong, but 70 is based on not on the basis of contract, on the basis that once you enjoy the benefit, you cannot say. Before enjoying the benefit, government should say, no, we will not use it, we will not do it, you have done by yourself. Then, my lord, law says that I cannot force the government at that situation, my lord. Then Section 21, para 21, my lord. I'll just read these two paragraphs, then I will conclude my argument. The principle flowing from the above observation made in MSO and so and son, it is that when the contract is illegal, but in execution of such a contract, a party has derived benefit. The party who derives and accepts the benefit has to compensate the person from whom such benefit is derived and accepted. And though a contract is illegal, the fact remains that if in terms of the contract, the government has derived the benefit or received delivery of property, the government has to compensate the person who delivers the property or from whom the benefit is derived by the government. In the present case too, the government has received the benefit of delivery of PDS items through carriage contract from the present. Even if the contract in question, which was having been awarded without calling for tenders, illegal, the fact remains that the government is bound to compensate the appellate for the benefits
with it has derived by getting the PDS items carried from one place to another, so and so, my lord. Then, my lord, the para 26, how the quantum of compensation has to be paid, my lord, relying on apex court judgment, para 26, it says, my lord. While considering the above aspect of the present case, it needs to be pointed out that the real issue for claim under section 70 of the Contract Act is not the terms of the contract, but the quantum of the benefit actually derived. In the absence of any other material, the contract between the parties provides a reasonable basis for calculating the benefit. And hence, the only reasonable way of arriving at the value of the benefit derived by the government is to make the rate agreed upon by the parties to the contract as the basis for determination of the quantum of compensation. Inasmuch as the agreed rate, unless or otherwise, would be a fair indication of the value of the contract, we will so and so this judgment has been referred. Here in this case, my lord, so far government affidavit is concerned, they have not said that the work is of inferior quality. It's not, the rate is not properly quoted, my lord. Those are not in a dispute at all. Only the plea raised by the government. No, we have not given approval. We did not ask you to carry out the work. That is only the basis, my lord. So admitted position, my lord, my case, it's not something out of my whims I carried out the work. I constructed the main contract work. Then, my lord, will see. That is very important, that part, my lord. It is not something, my lord, useless property, my lord. In the basement area, my lord, there is a vacant area. My lord, that area has been converted into a lodge, my lord. And inside the Ganga lake, my lord, septic tank is to be required, my lord. Those are the required properties, my lord. It is not something that unnecessary things, my lord. Restaurant, my lord. Those are the essential basic amenities for the tourists, my lord. So every assets were created, my lord, as the estimates given by the executing authority, my lord, in my case, my lord. My lord, may I come to page number 8 of my, what are the additional contract work I have done, my lord? My page 8, my lord.
Yes.
My 4 staff quarters with attached toilets and bathroom. There was, my lord, staff is required, my lord. That was not in the first these things, my lord. So in the basement area, this has been done, my lord. Septic tank, my lord. These are not, my lord, unnecessary. Police bed point, police duty room, my lord. Then thereafter, my lord, restaurant, my lord. These are the work, my lord. I will take to certain and these things, my lord. My lord, kindly turn to page number 28, my lord. Annexure P3. This is the estimate made by the, my lord, executing agency, my lord, RWD, my lord. Then, my lord, kindly turn to page number 31, my lord. 31, my lord, right side, my lord, will show additional work for parties, my lord. That, my lord, this is the basement, my lord. Above is the this is the main, my lord, contract work. This is tourist work, my lord. Below, my lord, this area was vacant. So the executive engineer said, my lord, he had the concurrence of the government secretary. So let's use this part also, so that even parking lot will be better. It will be more strong. So this entire unit was where, my lord, constructed by me, my lord.
Yes.
Then, my lord, will see. In, my lord, may kindly turn to page number 39, my lord. Then, my lord, the executive engineer, he writes to the director, my lord, tourism, intimating that these works have been done. Now, these are the estimates, these are the money need to be paid. My lord, then, my lord, tourism department has not denied, my lord. My lord, that will be clear from page number 40, my lord. Kindly turn to page number 40, my lord. Now, the tourism department is saying to the executive engineer, because by that time, what happened, my lord, bifurcation took place, that tourism department started having its own engineering wings. Then director, he writes, my lord.
Now, may allow him to read this 39.
Page number 39, yes.
39.
The RWD, he wrote it to the director tourism.
39
Yes.
of repetition.
Yes, page number 39. With reference to, I am submitting here with an additional estimate for so and so, along with self-extremity for seeking additional fund.
Page 30,
39, my lord.
annexure P5.
P5, my lord.
Hmm.
Then executive engineer RWD, my lord, at that point of time.
Hmm.
Then after this letter, my lord, will come to page number 40. Then, my lord, director writes to its own engineering wing, Department of Tourism, executive engineer. You do the verification of the additional work. My lord, that shows that now the question is not that whether the director has the authority.
What is this letter?
Asking
At page 39?
39, my lord, intimation
Ah.
by the RWD executive engineer and seeking additional fund, my lord.
On what basis?
Saying, my lord, that these are the additional estimate for the work, my lord.
Ah,
My lord, may I read again, my lord?
yes.
With reference to the above side, I am submitting here with an additional estimate, my lord.
Ah,
Additional estimate, my lord, the additional work, my lord.
yes.
For additional work at Ganga Lake, Itanagar for an amount of rupees so and so, so and so.
Hmm.
Only along with self-explanatory by Samadhanam so and so. My
Who is-
note is, my lord,
Who is
is
this Samadoro?
I am petitioner, my lord, though I have carried out that work, additional work.
You will make your own estimate.
No, my lord. My lord, I have not made an estimate, my lord. I have shown you the estimate, my lord. It's in page number,
This executive engineer is acting,
my lord,
Active-
page number 28, my lord.
this executive engineer appears to be acting at your dictate.
My lord, those are whatever the
When
issue,
it comes to you, those are,
my lord.
huh?
Only the issue remains whether work has been done, enjoyed by the government or not. That is not in dispute. If my lord, ultimately one has to be fair. You can't take the because only officer have asked me,
Who has to be fair?
government, my lord, principle of unjust enrichment.
Petitioner is not to be fair.
I feel I have done the work, my lord.
Okay.
I am not asking freebies, my lord. There is no dispute. I have done, I have put my money. And the law says, my lord, when such thing is done, law comes in justice says, substantial justice say, interest of justice says, other person cannot take the benefit. It's called the principle of, it's hit by the principle of unjust enrichment. This is entirely the foundation of Section 70. This is how we have moved into civilization. This is how taking into consideration.
We
This
have
is
moved
how the
into-
evolution of law, man.
Okay.
In 62 only, we have adopted this principle, man. Earlier, we used to have
62, you have adopted this
principle.
principle. What is that? Unjust enrichment.
Unjust.
What is the, this concept of unjust enrichment emanates from which section? Section 70 of the Contract Act.
Contract.
This section existed since 1872,
1873,
1873.
1970 something. But the question is that,
So you have,
question was that this
evolved
was
with-
not applied against government.
you have
This was not applied against government.
evolved with only.
Because earlier, this was used
All
only
right.
against,
Anything else?
well, that's all my final conclusion, man.
Ah.
So my case.
No, we'll
finally-
continue at 2.
Well,
Yes.
well,
I would like to mention this item number 24, my lord. I'm not keeping well, my lord. I have taken consent from this also. Item number 24, my lord.
24.
My lord, it may be listed after 2 weeks, my lord. I'm not keeping well, my lord. And
What
this
is 24?
24 is a read petition, promotional matter, my lord. Everything
Close
completed.
list is beneath this residence. Yes. What is 24?
24, it is a promotional matter, my lord.
Ah.
We have completed our pleading and all ready for hearing, but I'm not feeling well, my lord, and it is not likely to reach today also, my lord. So,
This is 2016 matter.
my lord, maybe listed after 2 weeks, my lord. I've taken consent from the,
After 2 weeks.
my lord.
What happened to audio? Huh? Yes, after 2 weeks.
Oh,
So, my lords, that so far specific query, my lord, that in such situation, but the option left with the law. work done by you. Because the same was without approval for those things. So in that situation, my lord, risk lies with me, man. My lord, that particular, my lord, paragraph, may I read, my lord, that particular situation, my lord, how, what's the option left with the government in such situation? When the work, contract work is done at the instruction of the official, or even there is no instruction. My lord, we can go to the extreme example also that there is no such instruction even. But I have done by my own self. But knowing that I am not doing gratuitously, tomorrow I will claim the compensation from the government. And the government later uses that property. And here is the case, government has earned revenue. Has been earning revenue, my lord. Still the property is intact, the government is using it.
Yes.
So this all aspects has been discussed. Well, just one illustration I will read, my lord. Kindly turn to page number 15 of para 15 of my lord, that BK Mandal case itself.
Yes,
One illustration, para 15, my lord, then from the bottom, my lord, 1, 2, 3, 4, 5, 6, 7. 7 line, my lord, from the bottom.
yes.
The respondent says that it has done some work which has been accepted and enjoyed by the appellant. And it is the voluntary acceptance and enjoyment of the said work which is the cause of action for the alternative claim. Can it be said that when the respondent built the warehouse, for instance, without a valid contract between it and the appellant, it was doing something contrary to section 175 so and so? As we have already made it clear, even if the respondent built the warehouse, he could not have forced the appellant to accept it. And the appellant may well have asked it to demolish the warehouse, take away the materials. Therefore, the mere act of constructing the warehouse on the part of the respondent cannot be said to contravene the provision of section 175 so and so. In this connection, it may be relevant to consider illustration, one illustration. The said illustration shows that if a tradesman leaves goods at B's house by mistake, and B treats the goods as his own, he is bound to pay A for them. Now, if we assume that B stands for the state government, can it be said that A was contravening the provision of section 175 so and so, when by mistake he left the goods at the house of B? The answer to the question is obviously in the negative. Therefore, if goods are delivered by A to the state government by mistake, and the state government accepts the goods and enjoys them, a claim for compensation can be made by against the state government and so and so and so and so. So even, my lord, that request is also not required. By mistake, even if I construct. But ultimately, my lord, whole basis is, my lord, the equity. The principle of injustice, enrichment. You cannot take advantage of others.
Yes.
Now, my lord, with that, my lord, I'll sum up my case, my lord. So far, the pleading is concerned. So far, in my case, no dispute. So far, the work has been constructed. No dispute so far, they have been using it. The contention only no approval, no consent given, that is only. Now, so far, they have not disputed the quality of the work, not disputed the rates, estimate rate submitted by me, my lord, that being claimed by me. On this aspect, not disputed at all by the state government. Only the thing there, please, that no approval, and I did not ask, there is no approval for the government. And the series of judgment, my lord, it shows, my lord, that in such situation, my lord, when 76 applies to the facts, then because the claim is not on the basis of contract. Claim is on the basis of equity that has been enacted in the statutory form of section 70 of the contract. This was developed in the equity code earlier, which has been given the statutory color by way of the Indian contract. And in 1962, it was formulated by a constitutional bench, and whereby, my lord, this principle has been applied against the commoners.
Where have you stated that the department is using
My lord, I have stated. my lord. And they have not disputed that fact also. my lord. My lord, my lord will see, page number 11. Page number 11, L, my lord, para L, my lord.
Your paragraph is numbered as A, B, C,
L,
D.
L, my lord. Relevant facts I have put in A, B, C, D, something like that.
This, all paragraphs are numbered as A, B,
No, my
C.
lord, some of the 1, 2 also, my lord, it's something like, my lord, para 5 is the relevant facts, my lord, then under it, my lord, A, B, C, my lord,
L is the part of para 5.
para 5,
Okay.
para 5. The respondent belatedly replied, whereby it unequivocally admitted the writ petition had executed the so by investing of money on his brand without taking and the instruction and so is were being used by the concerned department. My lord, this is an admitted position even.
Where?
My lord, L.
Okay, used by the consult department.
My lord.
Okay, all right.
My lord, we will see. Many paragraphs, my lord, I have mentioned, my lord. This even, my lord, I have constructed the design and specification also provided by the, my lord, RWD department. It's not something, my lord, I have done by myself.
This executive engineer of the RWD department.
RWD at that time, my lord, because the tourism department did not have its own engineering wings, my lord. It was done through the executive engineer, the RWD. Not contributed to this fact, my lord, by the RWD, the executive engineer also. So, my lord, this principle only, my lord, I am seeking the relief, my lord, since they have not disputed so far my claim, even the money, my lord. So, my lord, you kindly consider my prayer, my lord, and in the interest of justice, my lord, appropriate direction will pass on this, my lord. Amenities infrastructure are still in existence. They are still using them since last 13 years. my lord.
So the short submission which you have advanced is
My lord.
that we have a parking issue here, parking space issue here in the High Court complex.
My lord.
You know that there is a lot of space for the parking for the vehicles of the lawyers as well as for the staffs. You know that. Suppose the registrar asks you to construct a parking lot. There are empty spaces. And you construct a parking lot. Is the High Court bound to pay you?
If High Court uses it.
If High Court,
Law says.
okay.
If High Court has the option.
Ah,
No, I will not accept your parking law. This is entirely, the entire case rounds there.
okay, all right.
Once you use it, you are bound because unjust enrichment, you
Okay.
can take the benefit.
All right.
May I plead your lordship,
Hmm? Yes.
on behalf of tourism, my lord.
Hmm.
My lord, this court, my lord, has dismissed a similar case, my lord, with an observation that Section 70 of Indian Contract Act will attract only if anything has been done lawfully. And here only name of the petitioner and the place of tourist laws where it is located is different, my lord. This is in respect of tourist laws at Ganga and Ganga Lake, and one at Vintage Point between Naharlagan and Itanagar, my lord. While disposing of death case, my lord, this court has observed that there is no, since there is no material to show that he ever executed any work, my lord, he cannot be allowed to pay any compensation, my lord. Merely on, my lord, estimation prepared by an engineer, that do not authorized by the department, my lord, he cannot invoke the extraordinary jurisdiction of this court, my lord. If this trend is not restrained, my lord, the people with muscle power and political influence, they will just start executing work and started claiming compensation from the department, my lord. And
That writ petition is 354 AP of 2016.
No, my lord, that is another case, my lord. This is the one I report is my lord, page 17, my lord. 17, my lord. Page 17 of my affidavit in opposition, my lord. Here in this also, my lord, the petitioner place reliance on BK Mandal case, my lord. But that was rejected by this court. Because the nature of the case is different, my lord. And at any point of time, the tourism department had accepted that he ever executed any work, my lord.
Yes.
No, he was not authorized by anyone. Only when, my lord, a representation for payment of compensation was submitted, the department came to know that he must have executed some work, but department has never considered, my lord, that he has ever executed any such work. And there is no material evidence, my lord, to show that he ever executed any such work.
Okay.
And my lord, in any case, my lord, the WPC 354, which was disposed of in 2016, my lord, that is not exhausted, my lord. And the petitioner had not challenged that order, my lord. Whereby, my lord,
it is for the same work.
Yes, my lord. Same work, same picture. No.
When was the work executed?
My case, my lord. My lord, it was 2009, my lord, 2008, 2010, my lord.
2010. This writ petition was filed when?
This petition filed, my lord,
2020.
20, my lord. Work complete, my lord. My lord, what happened there, my lord? I was the leasee of that Ganga Lake, my lord. So I was allowed to continue use this Ganga Lake, my lord. So only later on, my lord, that was cancelled, my lord.
No, that's wrong submission, my lord. He was allowed.
354 was for which work? This
That was
where is
for
that work?
this. There is 354 was challenging, my lord, the cancellation of my lease agreement for my lord Ganga.
Okay, all right.
It's not for my lord this case.
No, my lord. Here also he claimed the same relief, my lord.
No relief, my lord. Only their contention was raised that land was given by me and so many investment I have done. So that's why lease should not be cancelled. That was the argument. My lord, if reads the judgment, my lord, it's so clear. Writ petition challenge the notice issued whereby to vacate the tourist so and so, my lord. Not this case. It's the challenging that. Therefore, that court happens.
Okay.
This court, my lord, made the observation. If you want about any those kind of compensation, you have an appropriate relief. Now, my lord, so far judgment relied by my learned counsel, my lord, for the tourism, my lord, so far regarding single bench of.
There are 1, 2, 3, 4. It's mentioned.
55 of?
He have raised that issue also.
That was not the case, my lord.
Hmm. Yes,
So that committed there, he constructed 4 rooms on the third quarter, septic tank, with 3 point restaurant with sale, storage complex. For which all my trading money for about 38 lakhs in terms of assurance of repayment by the tourism department. But it is not failed to show any such
and
assurance.
assurance given by the respondent concerned. It is there at page 55.
Now, my lord. My so far, my lord, so far earlier petition is concerned. That was regarding challenging the cancellation of.
It
my-
looks like, but court
My
has,
lord, we'll see, record is not there,
Court-
which shows I never claimed compensation.
court has made some observation.
Observation, but subject
Okay,
matter, my lord.
Anyway, we'll not dismiss your case on this ground.
My lord,
We'll give some other ground.
my lord.
Yes.
Then, my lord, so far this 25, so far my learned friend is saying that that single bench judgment. Their single judgment said in that case regarding tourism, my lord will see. In that case, so far completion of work that has not been there. There is neither material nor record to show that the petitioner has undertaken the construction work, completed the same, or there is any material so that the respondent authority have any benefit derived therefrom. So that case is distinct record. That's why that case has been dismissed, because principle of section 70 will not be applicable. Because petitioner,
Petitioner will have time to reply. Let him submit first.
Okay,
If it goes like this, it will
Yes.
take 3 days.
all right.
My lord, the case is exactly the same, my lord. In that case also, my lord, only one estimation was prepared by the same executive engineer, my lord. So the fact is that, my lord, in connivance with that executive engineer, he tried to make out some, my lord, claim compensation, my lord, by executing work without any authority, my lord. In that case also, my lord, there was no such material or except estimation prepared by the executive engineer. And this is the same engineer. And at any point of my lord, the tourism department has accepted that he executed any work. We are denying from the day one. And my lord, the Reliance, my lord, cited by the petitioner, my lord, that is different in this case, my lord. The tourism department has not as of now accepted any use of the work executed by him.
All right, we'll pass order. Mr. R. Sunil Lalit, counsel for the petitioner. By referring to the pleadings made in paragraph 5E of the writ petition has further contended that the additional work referred to here and above was executed by the petitioner on a direction by one engineer, Toko Otu. Full stop. Engineer Toko Otu is stated to be an executive engineer. of the Rural Works Department. Full stop. If other. Yes. Well, the counsel for the petitioner. What are contents that pursuant to the work pursuant to the additional work executed by the petitioner as above. The Department of Tourism is using the infrastructures constructed by the petitioner and because of the above facts, comma, in terms of the provision of section 70 of the Indian Contract Act 1872. The Department of Tourism is duty bound to compensate. Word is compensate. Okay. Compensate the petitioner for the works the petitioner has executed. Also, in support of his contention, the counsel for the petitioner has relied on the following decision. 2009 4 GLT 314. Two 2023 SEC online Guwahati 2150. Two 2020 3 GLT 4 sorry GLR 415 and AIR 1962 Supreme Court 779. Also, I have considered the submission made contention raised by the learned counsel petition and the decision relied upon by the learned counsel for the petition. Section 70 of the Indian Contract Act 1872 reads as under quote 72 sorry 70. On reading of section 70 of the Indian Contract Act 1872, it appears that the three ingredients to support the cause of action under section 70 of the Indian Contract Act are the following. Firstly, the goods are to be delivered lawfully or anything has to be done for another person lawfully. Semicolon. Secondly, the thing done or the goods delivered is to be done or delivered not intending to do so gratuitously. And the third, the person to whom the goods are delivered enjoys the benefit thereof. Full stop. In the counter affidavit filed by the respondents number 2 and 3, the paragraph 8 of which has already been quoted here in above. It has in paragraph 8 of the counter affidavit, which has been quoted here in above. The Department of Tourism has made a categorical statement that the construction, the additional work, the construction of the additional work is stated to be undertaken by the petitioner must have been undertaken and carried out by him through his own resources and at his own capacity, and the Department of Tourism had never approved and asked the petitioner to undertake any such construction. Full stop. In view of the above amendments made by the Department of Tourism, that the Department of Tourism had never approved the additional work done by the petitioner, it cannot be said that the petitioner had executed the additional work lawfully. And therefore, the first ingredients of section 70 of the India Contract Act is found to be absent in the instant case. Full stop. The petitioner may have executed the work, additional work, not intending to do so graciously, and thereby may have fulfilled the second condition, second ingredient of section 70 of the Indian Contract Act. But insofar as the third ingredient of section 70 of the Act, which is that the additional work executed by the petitioner has been used or enjoyed by the Department of Tourism, the Department of Tourism in the counter affidavit file in paragraph then thereof. Just a moment. In the counter affidavit filed by the respondent number 2 and 3 have not found to have been admitted in the counter affidavit file. Have not unequivocally admitted the fact of user by the Department of Tourism to the additional work executed by the petitioner. Full stop. In the absence of any such admission in the counter affidavit filed by the Department of Tourism, that the Department of Tourism has been using the additional work that has been executed by the petitioner. It may not be possible for this court exercising jurisdiction on Article 226 of the Constitution of India to record a categorical finding that the additional work executed by the petitioner has been used and enjoyed by the Department of Tourism. And as such, it can therefore not be said that the third ingredient of Section 70 of the Indian Contract Act has also been affected in the instant case. Under the aforesaid facts and circumstances of the case, this court is of the considered view that no direction can be issued to the respondent authorities to compensate the petitioner for the additional work alleged to have been executed by the petitioner as above, comma, in terms of Section 70 of the Indian Contract Act 1872.
My lord has not done, I think, legal notice reply filed by the government where they have admitted that all works carried by me. My lord has not done it. Page 46.
In paragraph 10,
Maybe legal notice, they may lie, my lord.
I was going to refer to that, but I have said that in the just.
And my lord, so far lawful relationship, Supreme Court has Constitution bench has discussed. Lawful in the sense, once you give the thing, you take the thing, then it becomes lawful. I think my lord will find there are 17 has discussed what is lawful.
Which one? Huh?
What is lawful?
I have said so. I have a reference also, but I have not given the reference. And this is in addition to what is there.
Right.
Huh? Accordingly, accordingly, I find no merit in the writ petition and the same instance dismissed. Here it is, that day it was Singhe. You change it to Arsono.
My lord, this is a contempt petition, my lord. The applicant is no more my lord, but still my lord, this can be proceeded.
Affidavit filed.
No, my lord, I'm so sorry, my lord. On the last few occasions, the counsel for the petitioner had been taking time saying that they'll be filing a substitution petition. But since, so we were of the view that the case might not be proceeded. That is why that affidavit was not filed. Since he's saying that even without substitution is going to proceed with the case, then I'll file affidavit within a week, lordship.
Yes.
Some time may be given.
What is the order? Order of the court.
Page 10 onward.
Operative part.
Operative part is paragraph, page 12, paragraph 6 onward.
Paragraph 6.
Yeah.
Okay, all right. Mr. N Pada, London Council for the petitioner and Miss N Dange. For the sole respondent?
Sole respondent.
Okay, for the sole respondent, who prays for. And granted further 2 weeks time to file to file affidavit, listed after 2 weeks.
Obliged.
Item number 5.
I think number 5 to 10, similar method, land compensation method. Feelings are not completed in this.
5 to 10.
Yes,
So, land compensation matter.
yes, ma'am.
That
Four
that
lane-
whole leaning of the
four-
matter. Who
Only respondent number 3 has filed DD. And we have filed affidavit in reply to the affidavit of section of AC.
only deputy commissioner has filed affidavit.
Yes. And my lord, similarly situated matters are there. Day before yesterday, one matter was listed and it has been fixed for after 2 weeks. now.
Then what is to be done? All this matter has to be
Second,
taken up together.
yes.
Today, how many matters are listed?
6 matters.
6. And you have altogether how many matters? How many writ petitions?
About 10 to 12.
Why don't you give the number?
Yes, Your Honor, in affidavit in opposition filed by the DC, they have denied in 2 categories, 3 categories. In some of the petitions, they have said that we are not giving compensation because this falls under right of way. And in some of the petitions, they have said that the forest department has not given anything. So my lord, after the readings are completed, we will segregate the matters and give list to the.
No, even at this stage, we can list it together.
Yes,
You give the rest of the numbers.
yes, you,
Here it is what 6 writ petitions are there.
yes,
You have altogether 10.
yes.
You give the remaining for number of 4 writ petitions.
My lord, if I may be allowed to give it to the registry, the list of- for
Yes,
tomorrow,
tomorrow.
yes.
Okay, all right. We'll say. You want to file affidavit?
No, no. Sir. We are not denying it, no, sir, we
All
are
right.
constructing a
This is
road.
6 to 10, na?
Yes, 5 to 10.
5 to 10. On the prayer of Miss M. Carver, London Council for the petitioner. List these writ petitions along with so and so after 4 weeks.
2 weeks,
Okay, after 2 weeks. You give the number
yes.
tomorrow. Huh? Okay.
Lordship.
Yes.
Lordship, Mr. Tijamo, he left for his home due to his illness, Lordship.
What is this matter about?
Lordship, yesterday I have apprised this court that department has already paid the salaries of this
Oh, yes,
petitioner,
yes.
Lordship. So I have come with, today I have come with the
Okay,
record, Lordship.
all right. In this writ petition, petitioner is asking for salary for which period?
Lordship, from the date of appointment to till the date of termination, Lordship.
What is the date of appointment? (26) 10/2017
Lordship,
to 17/7/2019, I think.
2019, Lordship.
you just correct me, correct the court, right? Because court is reading out from the prayer of the writ petition. Prayer made writ petition. 2019. Okay. Then, petitioner was what?
Lordship.
Petitioner was? Teacher,
There is Lordship, two similar cases there, Lordship, 180, WPC 180 and 181, Lordship. One was
180 is
180, he was appointed as junior engineer, Lordship.
okay, junior engineer.
Lordship, payment was done on 12th January of 2022, Lordship.
20. Lingdung Pacha.
Lordship.
Yes, Lingdung Pacha. Putting for 1st October to 17 July, correct? All right. Then. You write in WPC. This week, none of us for the petitioner. This writ petition has been filed by the petitioner for providing financial benefit salary, I think, huh? This we filed by the petitioner to provide salary. Petitioner is still in service.
No, Lordship.
Okay, terminated. no?
Terminated, Lordship.
Okay.
They were no more in the job. Lordship.
Salary for the period 25/7. He has two prayers. One is outstanding monthly salary with effect from 26/10/2017 to 17/7/2019, which by this order, you appears to have sanctioned the amount. Another prayer is back wages 25/7/2017 to 17/7/2019 at page 36. Any idea in this?
Lordship, this party has filed one WPC here in this honorable court, Lordship, which was disposed of, Lordship.
No.
On 25/10/2019, Lordship.
All right, anyway. Not this. This writ petition has been filed by the petition for a direction to respondent number 2. Who is respondent number 2? To release the outstanding monthly salary of the petitioner with effect from 26/10/2017 to 17/7/2019. During which period the petitioner states to have worked as junior engineer.
Junior engineer, J.
In the Department of Education.
Education,
Okay, in the Department.
engineer wing of Department of Education.
And a junior engineer in the engineering wing of the Education Department. Mr. Ketava.
K. Tabang.
Learned Council for the Education Department has produced before this court an approval stock sanction order dated 26 December 2021. Issued by the Deputy State Project Director Samagra Shiksha stock ISSC Arunachal Pradesh by number so and so it is here, huh? Where an amount of rupees 5,72,000 being the salary of the petitioner with effect from 1st October 2017 to 17 July 2019. What approval or sanction order? Huh? Where, and administrative approval. Stock sanction has been accorded for an amount of rupees 5 lakhs, etc. Huh? You add that approval, huh? For sure. In that view of the matter, this this writ petition shall stand closed in terms of the opposite sanction order dated 26 December 2021, which is written on record and shall form part of the record and mark the X for identification. Now come to second case.
Similar case, Lordship, but Lordship, post is different, Lordship. He was holding draftsman, Lordship.
Draftsman.
Lordship.
No, this earlier petitioner was also a draftsman. Lingdum Pacha. JE and draftsman are not same.
No, Lordship.
But you have written here draftsman in your order produced. You have a copy?
Lordship.
You see? Draftsman.
Lordship, Lingdung Pachai, he is a junior engineer, Lordship. He was junior engineer, JE.
But why?
And Lordship, Baketamai is a draftsman, Lordship.
But you have addressed the Lingdum Pacha as draftsman.
Lordship, may I take this Lordship to page number 5, Lordship, of this record, Lordship. Here, Bagetama has been mentioned draftsman, Lordship.
That's all right.
By the department.
Bhagatama, there's no confusion. Draftsman,
Lordship.
But here, Lingdun Pacha is J.
J.
Was a J.
It was a J.
But you have mentioned as a draftsman in your approval letter. Do you have a copy of it?
Lordship,
Is not it?
Lordship. Maybe clerical Mr. Lordship.
Then second writ petition 181. This writ petition has been filed. Period is same. Draftsman.
Draftsman.
Okay. Huh? Okay, this writ petition has been filed. Non-abusable petitioner had Mr. K. Dawal under counsel for the education department. This writ petition has been filed. Taking a direction to the respondent number 2 to release the outstanding monthly salary of the petitioner with effect from 26/10/2017 to 17/7/2019. Full stop. Mr. Kava under the counsel for education department has produced before this court and order dated approval stock sanction order dated 3/9/2021. Issued by the Deputy State Project Director, Samagra Shiksha ISSC, Arunachal Pradesh. However, an administrative approval stock sanction has been accorded for an amount not of rupees 5,60,733. Being the salary of the petitioner who had worked as a draftsman in the engineering wing of the education department with effect from 1st October 2017 to 17 July 2019. First, in view of the above, this writ petition shall stand closed in terms of the approval stock sanction order dated 3/9/2021. Report to hear in above.
Yes.
And we write a copy of the approval or sanction order dated so and so issued by so and so produced by K Tower and representing council for the council for the education department is taken on record, which shall form part of the record and shall be marked as X for identification. Yes, what is to be done? Petition, you have a petitioner? No.
My lord, in item number 13 and 14, I am for the petitioner, my lord. And in item number 12, my lord, I am for the respondent. Since Union of India has also implemented it. But these all are, my lord, similar and connected methods. So today, my lord, this is since the counsel for the petitioner in item number 12 is not present today.
Navam, you are contesting this case.
My lord, yes. My lord, in this case, what I have seen, basically they have challenged the constitution of fact finding committee. Now fact finding committee was constituted by the government, headed by the, my lord, commissioner, then the secretary land management and directors. Now, in this case, my lord, their affidavit is very important. As on that, my lord, neither in Potin to Bopi or in this case, they filed the affidavit, my lord.
Who?
By the land management department.
Yes.
So their affidavit is very important.
My lord, precisely, there is no provision as such under the, my lord, the Right to Fair Compensation Act 2013. There is no provisions for, my lord, exactly constituting the, my lord, the fact finding committee, my lord. Once the compensation amount has been dispersed, my lord, by the district administration, after assessing my lord, the properties and everything, my lord, there is no provision. And by, my lord, and precisely another, my lord, my limb of contention is,
My lord, I beg to differ with the.
there is no, my lord,
Public money can be shifted in that style, my lord.
my lord, there is no, my lord, even the order of the government of Arunachal Pradesh for constituting fact finding committee in my case, my lord. in item number 39. There is no order as such of the government, my lord, by constitution of my lord, the fact finding committee. And in item number 14, in item number 14, my lord, the compensation amount has been assessed. The lesser the amount I have been given. But later on, when I came to know, I demanded for the payment of the, my lord, the rest amount that has not been paid to us, my lord.
Yes, you'll file affidavit or not? You'll file.
Cases where the petitioners are challenging the constitution of the final committee. And in some of the cases, they are saying that although assessment was made, but compensation was not paid. In these categories of cases, where the assessment was made and compensation was not paid, here the affidavit filed by the petitioner will cover every case. Because assessment.
So you,
no,
you will file or not?
Wherever it is challenged, the petitioner has challenged the constitution of the fact finding complete law. There, in all those cases, also we can.
No, we are not concerned with all those cases. We are concerned with only these 3 cases.
Yes.
What do you have to say in this case? You'll file affidavit or not? Huh? When?
At least 3 weeks time maybe granted those. All the officers, those I am told that they have. What was it, district tour?
Huh? District tour.
Yes, for a system of this, all this publishing matters.
But this writ petition was filed
2019.
during the last election. The year of the last election. So your officer is still on tour.
So that I can commemorate this last chance granted to the department for filing. In fact, I have been.
What? You have been what? You have been what?
Previous and those kindly narrated my submission seeking last chance for this.
Of late.
For filing it may be recorded.
Of late, we have noticed that you have not been able to secure instruction from the department. From the government councils, we have noticed that Mr. Itori Rao is unable to secure instruction from the department. But he is not telling us the problem also. Then we can help him.
In fact,
You are also not telling us the problem.
in fact, our department losses are very.
See, after 4 years, you are asking another 3 weeks time.
The department is the losses is having what few numbers of officers.
Huh?
Few numbers of officers. And losses. And observe losses. Only the land department had. Most of the cases, pending before this honorable court.
Who
Is
said?
from the land management department.
Who said?
Who
observed?
On my record,
Ah,
400 cases.
ah.
Yeah, are pending, are connected with land management department.
What type of cases are there?
There are some additional cases, some complex, and there are these. This fact finding committee.
Just a
Has
minute.
been challenged by, I think, more than 40 petitioners.
Okay.
And there is a case of Coliseum. In place.
Coliseum is now stayed by Supreme Court.
Is, but losses, in 2 cases losses, Jahameter case and 1 case. The name of that petitioner. They filed SLP.
Attending that the solution.
If you're not keen to contest this matter, we can allow the writ petition, is not it?
We have to call this note. It was, I'm expressing as to why there is a delay from the part of the department also. There is not enough number of officers also. But this is the department which is having more cases in the Honorable High Court, even in the lower court also. So anyway, also that cannot be the excuse. I understand also.
It is.
My only prayer as of now would be also kindly grant me another 3 weeks so that we can file affidavit in this series of repetition.
It is because of the less number of officers in the department,
Under that circumstances.
or the officers in the department are not productive. We don't know, is not it?
My lord, if such is the position, my lord, the secretarial and management will be called for, my lord.
Hmm.
So many matters are being pending, my lord, without having affidavit, my lord.
One officer has already been called for.
Yes, 7.
Hmm.
So under that circumstances, my lord, only for them, my lord, for that reason, my lord, justice cannot be delayed.
None appears for the petitioner in item 12. Have Mr. M. Kato in item non-council petitioner in item 13 and 14.
13, 13, 14.
Are also Mr. R.S. Nawal, an additional advocate general, and Mr. D. Kamdu, the standing counsel for the land management department.
To increase. Make one straight to me. Ye to actually well settled. Same होगा ना? ये तो अच्छा है. Okay.
Who is still pressed for some time to file counter affidavit by the department. Despite the writ petitions being of the year 2019 and 2020. On the prayer of Mr. Kamdu, Learned Council for the Learned State Council LA, listed after 2 weeks.
Well, Lord's kindly observe, make also this observation that this is the last chance is granted to Mr. Kamdu. I am myself voluntarily
No.
seeking the process.
I have not observed it. See, we can take up the case even without your affidavit also.
Yes.
But since one of the council is not present, and Kato also appears to be not in a position to argue the matter for disposal today, at least. Huh?
Right.
We can, on the next day, whether affidavit, no affidavit, we can proceed.
Yes.
It is up to them,
Yes.
their choice.
After 3 years.
2 weeks, up to
2 weeks.
2 weeks.
After 2 weeks. Deeply obliged.
No, appears after 8 weeks.
In item number 17, my lord, I am for the private respondent, my lord. On the last occasion, my lord, in fact, I sought for the time for filing affidavit, my lord. So till then, my lord, I could not able to prepare my counter affidavit. So therefore, this is my lord, may I afraid that again, I may be allowed 3 more weeks times to file my lord affidavit, my lord.
What is the matter about?
This is regarding my lord,
Misappropriation of the food grain items.
Misappropriation of?
PDS food grain rice.
Then,
items.
then what are you praying for in this writ petition?
Is praying for I have filed the appeal before the Secretary Civil Supply.
Secretary Civil Supply.
That may be disposed of. This is long pending.
What kind of appeal you have filed?
Appeal, my lord, respondent number 4 and 4, who is MS Bomkar, has misappropriated food grain item of the PDS of the PDS. So the petitioner has complained against them, and DC complained before the DC, and DC has constituted a committee regarding the allegations to ascertain the allegations.
Where is your appeal?
Appeal, my lord, the next, my lord. My lord, since appeal petitions so bulky, my lord, so therefore I have not annexed that petition here.
Okay, can you dispose it of?
no, my lord, in fact, this is.
Directing this secretary to dispose of his appeal or application dated 1/10/2021. What is this application? File under? This is a statutory appeal.
My lord, file under, my lord.
Okay. Our Mr.
Or the go, my lord.
or Dugong Learned Council for the petitioner. At least tell us something about what is this appeal?
Well, appeals regarding regarding non-taken action against the respondent.
Non,
Taken actions, satisfactory action has not taken against the respondent. So, okay, for cancellation of their agencies, they have not taken any, just they have.
somebody appears to have filed affidavit, I think.
Yes, Your Lordship.
Uh,
One is
one means the Secretary Civil Supply.
2 and 3. Not 1.
2 and 3.
Yes, 2 and 3 they have filed.
What have they said?
Lordship, in fact, I'm appearing for the first time in this case, Lordship. So the previous, I'm not clear with you.
Mr. or Dugong Learned Council for the petitioner. M. Kato for whom?
Respondent number 4 and 5, my lord.
Okay, just a moment. Petitioners, huh? For Dugong petitioners. Miss P. Sangita, Learned Government Advocate for respondent number 1, 2, 3. And Mr. M. Kato, London Council for
4 and 5.
4 and 5. This writ petition has been filed, seeking a direction to the respondent number 1 to dispose of the appeal stock application filed by the petitioners on 1/10/2021. Full stop. The appeal stock application stated to have been filed by the petitioner on 1/10/2021 have however not been annexed by the petitioner in the instant writ petition. Full stop. Be that as it may. Since in the affidavit must have said something about this. Okay. Just, appeal has not been annexed, no? The respondent number one has not filed counter affidavit. However, though, you read like this, though respondent number two has filed a counter affidavit, the respondent number one is yet to file a counter affidavit. Full stop. Since the petitioner has not enclosed the appeal stock application filed on 1/20/21. The nature of appeal stock application filed by the petitioner on 1/10/2021 can naturally be not ascertained. Be that as it may, since be that as it may, having regard to the limited prayer made by the petitioner to dispose of the representation filed by him on 1/10/2021 by the respondent number one, the secretary, food, civil supply and government wellness service. This writ petition is disposed of by providing that the respondent number one, the secretary, food and civil supply, government wellness supervisors may dispose of the petitioner's appeal stock application dated 1/10/2021. If on its own merit in accordance with law, not may serve.
Madam. Reply.
My lord, yeah. During the last occasion, respondent number two, that is Deputy Commissioner, showed the time for filing counter affidavit.
What is the matter about?
It's about, Your Honor, I'm basically challenging the legality and validity of the summon issued by the respondent number two, dated on 17/8/2022, whereby he called back his own order after lapse of 5 months. So, in conjunction with the Arunachal Pradesh Land Settlement Records Act 2002, it's connected with a plot of land measuring 140 square meter at Nitibihar, Itanero.
My lordship, we have received instructions, my lordship, we'll be filing, my lordship. Some more time will be given.
You are for
Record
R2.
number two.
You are for?
My lord, I'm representing respondent number three and private respondent number 3 and 4. My lord.
3 and 4.
Yes,
Have you
my lord.
filed affidavit?
Yes, my lord, I have filed an affidavit. Oh, no, wakalat number, my lord. I may be given 2 weeks time for filing
What?
counter affidavit, my lord.
Wakalat nama.
2 weeks time for filing affidavit.
But you have said you have filed. No,
No. I have said, my lord, I have filed wakalat number, my lord.
you have filed wakalat nama.
Yes, my lord.
All right, nobody has filed. Nobody has filed affidavit. You are for whom?
But so I'm for the private respondent number 2 and 3. Sorry, 3 and 4.
But he is saying that he is appearing for 3 and 4.
We have this is item number 90.
Which item you are appearing?
This is item number 19.
Yes, 19.
I'm for that.
Donik, Donik,
We have received the plain copy.
Donik Tayo.
Lordship.
Who is your senior?
There's some mistakes. I think Lordship, there's some mistake, I think. We have, it's been a week, we received the plain copy, and today we are about to file our wakalatnama.
Well, during last occasion, they have respondent number 4, 3 and 4, they have filed some wakalatnamas.
Who?
Private respondent number 3 and 4.
No, which council?
Yes,
Which council had represented earlier?
maybe.
All right, both of you sort it out. We'll adjourn the matter. Huh? What, Mr.
Tabatukut.
Tawatoku. Learned counsel for the petitioner. And Ms. K. Wangmo. Learned government advocate for R2. Who submitted instruction for filing of a counter affidavit has been received, for which he pressed for and is granted 4 weeks time. Okay,
My lord, earlier interim order may be continued. ma'am.
district after 4 weeks. Interim order pass, I just will continue till the next legal list.
Much older.
May I lordship?
Yeah.
Your lordship, I have taken press step. And ID card of respondent number 6 has been returned. And about respondent number 8, 9, 14 and 16 are still awaited. Your Honor.
What is the
And-
matter about?
This was regarding a service matter, Your Honor, of hydropower department.
What was be the important council for the petitioner. And Ms. P. Pango, yes. And government advocate. Yes, have you filed counter affidavit?
Yes, sir, Lordship, we have already filed.
Already filed?
Yes,
They
sir.
have filed. Your Honor.
Okay. Private service report on private respondent. Listed after 6 weeks.
Interim may be continued, lordship.
Then you will have to take fresh steps.
But I have taken the press steps on 21/6/16.
21/6.
Yes, accordingly, steps upon respondent 6 has been complete as ID card has been returned. Only it's awaiting.
6 is returned.
6, yes, 6 has returned. 8, 9, 14 and 16 are still awaited.
What is the address of 14/16? What is the address?
Address, lordship, it's in Arunachal only, lordship.
Or you take dusty service?
Lordship.
Okay. Yeah, that putting on a council for the in view of the office note dated since you find out from the record. Mr. Tripodia, counsel for the petitioner. Takes leave of this court to take dusty service upon respondent number 8,
8, 9, 14 and 16.
8, 9, 14 and 16. Was leave south is granted. Learned counsel for the petitioner shall take justice service upon respondent so and so within a period of 2 weeks. Thereafter, an affidavit to the effect shall be filed post listed after 3 weeks. Interim order pass shall continue till the next date list. Okay.
Deeply obliged.
May I please, your lordship?
But in this matter, the state respondent, more particularly Deputy Commissioner has filed affidavit, my lord, and the press steps upon the respondent number 5 and 6 has been taken up, my lord. Taken long days back, my lord. Now, my lord, the affidavit on the part of the, my lord, the respondent number 2, 1 and 2 will be, my lord, required, as because this is, my lord, something which requires to be decided for fixing of the rate for the first position, my lord. The annual lease, my lord, lease rent for the first position, my lord.
All right.
There was a notification issued by the state government fixing the rate of the, my lord, the lease amount, lease rent per annum, my lord, from 2008. From 2008 to till date, my lord, there is no issue, my lord, as it has been already settled. Now, my lord, from 1962 to 2008, my lord, certain rate has to be fixed by the state government. And therefore, my lord, by notification 2008, my lord, the rate has been already fixed by the state government. Now the state government has to fix again, my lord, for the first position rate, madam. So therefore, this is my lord, the affidavit on the part of the state respondent as well as the, my lord, the private respondent, more particularly 5 and 6 is required.
Yes.
Yes, here also, lordship, we have not filed affidavit. And I'll be seeking time for 3 weeks again for this, for the department to furnish me with the separate comment for preparation of affidavit.
How much time? Will you file counter affidavit?
Again, 3 weeks, lordship, here in this case. 3 weeks.
What you will do in 3 weeks? You have not been able to do anything for the past 4 years. Talak for petitioner, Sangita for 1,
1 4 years.
1 for. Yes, Kamluk for 2 and 3. On the prayer of London State Council, listed of the 8 weeks. For filing of a counter affidavit. Post office.
And service report in respect of private respondent number 5 and 6 is still awaiting.
Registry shall issue reminder. For service report. To the Chief Judicial Magistrate. Town. Listed after 8 weeks.
My lordship, we have taken step for the respondent number 2, but till date we haven't received the AD card.
What is the matter about? Respondent number 2 is at which page?
My lordship, respondent number 2 is Yankee Enterprise.
Which page? Okay. Genco Enterprise.
Yes, my lordship.
What do you propose to do? You'll wait for the service report? Or you'll take fresh steps?
My lordship, fresh step may be given because we have already taken the steps long date before, but still AD card is not received, my lordship.
Or Miss Sironi,
Yes, my lordship.
your name?
T Yaram,
P.
Yaram.
Yaram. Learned counsel for the petitioner. Mr. Yes, what do you say, respondent?
Lordship, here I will not be filing affidavit, Lordship.
You are not filing affidavit.
Yeah, grievance, Lordship, they are seeking. Petitioner is seeking is from Deputy Commissioner and this company, Lordship, Genco Enterprise.
Sangeeta?
Lordship, I beg to pray for granting of some time for filing our CA. I beg to pray for granting of some time for filing.
No, have you received instruction or not?
Not yet.
Any urgency in the matter?
No, my lordship, we'll wait for respondent number 2 as well, my lordship.
That I'll provide. But any urgency is there? No urgency.
No, my lordship.
Because see, why I'm asking is, we are posting it after 8 weeks. If there is urgency, we can pass, we can consider your interim order. Otherwise, we will post it after 8 weeks.
My
Okay.
lordship.
Please, Sangeeta. Governor, 1,
1 and 4. Lordship.
1 and 4. Mr. Kamlu for 3. Mr. Kamlu, learned counsel for the Assistant Counsel for the Land Management Department submits that the Department of Land Management would not be filing a counter affidavit in the instant case. Ms. Sangeeta, I have request for some more time for filing of a counter affidavit in view of the fact that she is yet to receive and she is yet to receive an instruction from the department. Yes. In view of the above, in view of the above, listed after 8 weeks to enable filing of the counter affidavit by the respondents. Also, since the respondent number 2 is also yet to be served as indicated in office note dated 24/7/2023, Ms. So and so, on counsel for the petition, press for and is granted 1 week time to take fresh steps for service of notice upon the respondent number 2 by registered post with AD as well as by usual process. Listed after 8 weeks.
And your place.
Mr. S. Tapin, he is in other court, so this matter will be listed tomorrow, my lordship. It's a bit special.
Next week.
No, my lordship, Monday.
Huh?
Monday.
Monday is next week. Okay, next
Monday.
next week. Yes.
Here in this case, my lord, the case before the lordship is, my lord, we are assistant engineer at the time of the filing of this case, assistant engineer in the Department of the Power. And we are the direct equities. We are the best of 2005 and 6. Therefore, our case is that in the department or in our post, as per the recruitment rule, there are 2 sources, direct and equities. Therefore,
in order to maintain the inter seniority between the two direct and the equities, there is a notification from the government, central government, as well as the state government that rotation system known as rota quota, and that has not been applied by the department. As a result, while preparing the seniority list, the department has prepared by giving the preference to the promotee list, and thereafter our name has been serially put behind the promotee list. Therefore, we have filed a representation before the concerned authority that is the
You want to be senior to the promotee.
my lord.
In the-
We want that the seniority should be maintained as per the rota quota, rotation system.
Final seniority has been published.
My lord.
Final seniority list has been published.
Final not yet published, but so far the seniority list is concerned, we are keep below the promotee list.
What kind of seniority list? Provisional. Provisional seniority list.
Provisional seniority list.
Where is that?
My lord, may kindly come to page number 17.
17.
Yes.
Sixteen.
It is there from 16, and my lord, our names are appear start from serial number 50 to 54, who are the petitioners,
Okay, 52.
54.
Yes.
Therefore, against this provisional seniority list, my lord, this has been made as a final seniority list.
This is a final seniority list.
This is the seniority of
2013.
13. So in agreement of this, we have filed a representation before the concerned authority, which my lord will find the same representation on.
Since 2013, there has not been another seniority list.
My lord.
This is,
Yes, it's still my lord.
yes. So you want to be placed above whom?
Above those which has been, my lord, appear start from serial number, my lord, 39. Our contention is it should be 39, thereafter from 49, then 51, then this should be, my lord. This
No, just-
rotation should be,
How many petitioners herein?
we have
Five.
five petitions.
You are placed at serial number 50, 51, 52, and 53.
Exactly, my lord. Up to 54, my lord.
Sorry, up to 54.
My lord. Start from 50 to 54.
You want to be placed above whom?
We want to be adjust with the base, promotee base of 2005, which is appear, which are appear from the serial number 39.
39 to
30, since from 39, our rotation quota rotation should be start from 39. This 39 is the promotees, then one from the direct equities, then promotees.
Okay.
That is the rota quota, and that has not been implemented by the department. So, my lord, in this regard, we have submitted a representation and
affidavit file.
affidavit has not been filed, my lord.
No,
So far, what we have expected from the department is only to respond to
Yes,
the representation.
My lord will kindly turn to my lord his prayer. I think his case is not surviving now. The issue, my lord, his prayer, my lord. Only prayer, my lord, in this case, my lord. At page number 14, my lord.
Yes.
14, my lord. May I read, my lord?
Yes.
Read in issue administrative mandapa shall not be issued, directing a responsible authority power commissioner power not to hold any DPC in respect of assistant engineer IG from 205 base before finalization of representation date directed by High Court to dispose of in WPC number 394 2018. That double freedom, my lord. Now, my lord,
Before finalization of the representation directed by The High Court to dispose of.
No, some direction was issued, my lord, to dispose of their representation, my lord.
Okay.
Now, in this writ petition, my lord, they are only sole prayer, my lord, to not to all DPC, my lord. Now, DPC, I am informed, my lord, DPC was called on 2021, my lord, February, from 25 February 2022, my lord. They are now a regular EE, my lord, all the petitioners, my lord. Since February 2021, my lord.
DPC was held on?
DPC, my lord, DPC 25 itself, my lord, 25. 25, my lord.
25?
2021, my lord.
221.
Now, their prayer was, my lord, not to hold their DPC. They are the 2005 6 base, my lord. Now, their DPC was held, my lord. Now, they are, my lord. Since then, my lord, they are the regular.
Just where is this order passed in WPC 394?
394, my lord. They are the now what concept for the petition was submitted, my lord. They are grievance, my lord.
394.
My lord.
Page 55, my lord.
55. Here was the direction.
Operating part, my lord. Last para, my lord.
It's, to consider and dispose of the representation submitted of Bristol as per the procedure. Have you disposed of this representation?
No, my lord. My lord, I am to that extent, my lord, I'm not sure, my lord. But then thereafter, my lord, some seniority list was prepared, my lord, 2019, my lord. Though it is provisional, my lord. Their issue was, my lord, in the earlier writ petition, my lord. Their issue was, my lord, where the seniority list, my lord, should be maintained in the rota quota system, my lord.
Okay, there was no stay order from here.
My lord, I am not sure, my lord. Now, petition.
On 17/12/2018, my lord, the status quo was passed. As per this order, my lord, the status quo was supposed to maintain. But in the due course of the time, the DPC was held.
DPC was held.
Held.
When?
DP
25 to 2021.
Yes. And in the DPC, we have been also promoted.
As
a executive engineer, EE. But still, despite of the promotion also, promotion is not the issue. The issue which we have been raising from the very beginning is that rota quota should be maintained in the department.
But in the post of AE.
Yes, ma'am.
But now you are in EE.
Yeah, that's true, my lord. We are in EE. But till then, my lord, our seniority list is, my lord, below this. Due
in
to
the EE, executive engineer.
My lord.
Then you file a fresh case.
Yes, my lord. In this writ petition also, my lord, if they are agreed by a seniority list, my lord, they can avail other writ petition, my lord. Here, my lord, they are simple clear not to say DPC, my lord. Now they themselves avail that benefit, my lord, already, my lord.
What is remaining is, my lord, the representation has not been considered till today. If the we have ventilated
The
our
representation was for the AE.
no, my lord. Representation was praying for recast of the seniority list.
Seniority list in the post of executive engineer.
In the
executive engineer.
No, in the assistant engineer. And now still this is still a same seniority list.
You want to go back to assistant engineer. That is a history now. You have moved there.
Why?
Mr. C. Ordinary Council for the petition and Mr. How many petitioners?
5, my lord.
5 petitioners and Mr. L. Parman, Standing Council for the Power Department.
My lord.
Power Department. The petitioners while they were working as assistant engineer, electrical, had filed this writ petition seeking a direction to the respondent authorities not to hold any DPC in respect of assistant engineer within bracket E 2005-06 batch before finalization of the representation directed by the High Court to dispose of in WPC 394 AP of 2018. Also, Mr. L. Parmel, learned counsel for the though no counter affidavit by the respondents have been filed, Mr. L. Parmel, learned counsel, assistant counsel for our power department, has informed this court that the departmental promotion committee was held on 25/2/2021 for consideration of promotion to the post of executive engineer. From the from the post of assistant engineer. Post. And in the DPC held on 25/2/2021, the petitioners here have also been promoted as executive engineer in the department. In that, the above submission made by the council, council for the power department has not been controverted by Mr. C. Modi, council for the petitioners. In that view of the matter, this writ petition was filed hesitating the seniority position assigned to the petitioners in the rank of assistant engineer, and that now the petitioners have been promoted in the post of executive engineer. This writ petition has become infructuous. In the view of the matter, writ petition is disposed of as income. Okay.
My lord, the writ petitioner has filed for a direction from this honorable court to the respondent to release the pending bill, my lord, amounting to rupees 1,39,30,718 rupees. In respect of the works, my lord, executed by the petitioner firm for construction of road from Barming to Tayan stage 2, my lord. My lord, the bill prepared by the executive engineer is annexing Annexure 7, my lord, page number 9. This is the bill, my lord, prepared by the EE. Thereafter, my lord, the same has been sent to the empowered officer ARRDA, my lord, to issue the bank authorization. But my lord, they have not made the payment as yet. My lord, in their counter affidavit, they are saying that the central government has directed to not make the payment due to the SIC inquiry on the said project, my lord. In that regard, my lord, we have filed an additional affidavit, my lord. My lord, we have annexed the copy of letter wherein the SIC inquiry has been closed, my lord. It has been closed on February 2023, my lord. My lord, will find the letter in my additional affidavit, a copy of letter dated 21/2/2023, page number 17, my lord. My lord, typed copy is in page number 18. Subject, my lord, approval of the competent authority for closure of SIC case inquiry regarding gross irregularities. My lord, they have not denied in their affidavits about the pending bill, my lord. They've just said that it has not been paid due to the inquiry. My lord, other similarly situated matter, my lord, has been disposed of, my lord. And payment has been made to those petitioner, that petitioner. Nayak. My lord, similar direction may be passed.
Not similar direction. Here they have denied irregularities. There are several irregularities.
In the same project, my lord. 12 projects. This also comes under that 12 project, my lord.
In your paragraph 13, you have said you have executed the work and have not paid 13 crore, etc. Is not it? Paragraph 13.
Paragraph 1, 2.
Yes,
Yes, my lord.
that is your statement.
Yes, my lord.
Can you see the reply? At para 6 of the counter affidavit. With regard to statement made in para 13, deponent states that payment could not be released due to serious allegation of irregularities, and the matter is still pending with the ministry in spite of several communications from the state government. Therefore, the question of answering respondents' act per se whimsical, arbitrary, does not arise.
Yes, my lord.
So we dismiss this. Para 6.
But it was, my lord, same, this one,
Where?
it was in Naik infrastructure as well.
Hmm?
That these serious allegations were made by the complaints were from public. And then therefore inquiry was constituted, my lord. But my lord, that inquiry has been closed now.
Where is that? Where is that?
Closure of the inquiry
You have,
in additional affidavit, my lord.
so which paragraph?
With, may I read, my lord?
Yes.
With
Page?
reference to the aforesaid subject, I am page number 17, my lord. I am directed to inform you. that-
17.
Yes, my lord. 18, my lord, with the legible annexure is in page number 18. With reference to the above aforementioned subject, I am directed to inform you that the competent authority has approved the request for the closure of SIC Vigilance PS Inquiry number 37 of 2017 regarding gross irregularities in the 12 PMGSY scheme roads in the East Kamen district, Arunachal Pradesh.
Yes, correct.
My lord, our reason for not payment was the earlier irregularity, but that has been cleared by the SIC. Now, similar matter has been already, direction was passed. Now payment is also being made. Earlier, there was a complaint against irregularities of 12 projects, not only this project. And there was SIC investigation, and later on they had cleared the issues. And they have closed the investigation.
You take instructions on this additional affidavit?
Additional affidavit. In
If
other
they-
case
if-
also, we have already furnished. In other cases also, we have already apprised it. And this is not denied. Even we have sent to the ministry disclosure report.
Those which we have shown the document, this was filed by the government themselves. So we have made it as a additional affidavit here.
2009.
In other cases, they filed this document.
Our affidavit was 2000.
But in this case, they have not filed.
Additional affidavit, they have not filed.
2021 we have. filed.
This additional affidavit document which we have annexed, madam. This was the additional affidavit based on the additional affidavit which was filed by the respondent department, madam. In Naik infrastructure.
Who is the appropriate authority to give instruction? Secretary?
Secretary or chief
Chief
engineer.
engineer would be the
PM
best.
choice.
Okay.
Otherwise, my similar matter, your lordship has already disposed, madam.
Which one?
This is
No, here, there. it
the
was-
same, madam, same. This was here also, but the contention was same, madam.
Let us see that. Yeah, they had filed the additional affidavit.
Yes.
Yeah,
No, we have relied that documents of the additional affidavit.
here they will have to file. They will have to file, at least you'll have to take instruction, if you have to file.
Well, this is 2019 matter, madam. 2022 matter has been disposed of.
Otherwise, the same complaint case.
Same, same project area, madam.
No, see, here, see, he was given a specific, also the additional affidavit was, there, the additional affidavit was filed by under secretary.
Yes.
Then Monday, I'll take.
We
instruction.
relied on the documents furnished by the state respondent, madam. Now the matter has been closed, my lord, ultimately, madam.
Where?
Nothing survives. SIC, madam.
Let them say so. In that case, they have said, they had said so.
Let it be fixed on
Just, no, just, they have to file in writing. No. This writ petition has been filed. Petition. For payment of rupees 13,930,718.00. to the petitioner by the respondent authorities. For what work?
Construction of PMGS bio.
For construction.
From Bameng to Tayung, stage 2, Malad. It's a synopsis given.
For construction of
Road from Bameng to Tayung.
PMGSY road.
Yeah.
From Bameng to
Tayung.
Tayung.
Stage 2.
Stage 2. Bearing package number AR stroke 03 stroke 01 stroke 068.
Yes.
That is for 3 crore only.
Yes, Malad. Here we are demanding on 1 crore 39 lakhs. Project is not yet, Malad. Oh, not entire Malad amount.
Oh, you are okay. I thought you are demanding 13 crore. No, 1
No,
crore.
1 crore 39 lakhs.
Okay, okay, all right. That is the package, I think. Is not it? That is the package.
Yes.
Bearing package number AR 03
Yes.
is not
01068.
Okay, 068. Full stop. The respondent number 1 to 4 have filed a counter affidavit where in paragraph 5 and 6 it has been stated that there was public complaint regarding irregularity in execution of PMGSY road under Bameng RWD division. And when the matter was brought to the knowledge of the ministry, New Delhi, the ministry by letter dated 26/8/2019. Had directed the respondent authority not to release the payment. Full stop. Accordingly, it has been stated that payment to the petitioner could not be released due to serious allegation of irregularities, and the matter is still pending with the ministry. Full stop. The petitioner in the meanwhile has filed an additional affidavit. Wherever a letter dated 21st February 2023 written to the Superintendent of Police SIC Vigilance by the Undersecretary Vigilance Government of Andhra Pradesh by number VIG-33/2017/2034. Whereby it has been informed that the competent authority has approved the request for the closure of SIC Vigilance PS inquiry number 37/2017 regarding gross irregularities in the 12 PMGSY scheme roads in the East Tamil district under Supervis. And light of the above additional above letter dated 25 February 2023. Let the Department of RWD file an affidavit to indicate as to whether there still remains any impediment on the part of the respondent department to pay to the petitioner the amount claimed in the writ petition for execution of the PMGSY road mentioned earlier. Yes.
Copy of the same furnished to me, that order.
First August, Malak.
First August. Let a copy of this order be furnished to Mr. Taro. Standing counsel for the RWD for doing the needful by the department also.
First will be too early, I think.
So let the affidavit be filed within
12th August, Malak.
let the affidavit be filed within
12th August, Malak.
We'll say after 2 weeks.
Yes.
Let the affidavit be filed.
Yes. Always.